Students are joining. We'll start in a minute. Hello, good morning, and welcome to Byju's Exam Prep. In the last class on Friday, we initiated a discussion on citizenship. Now, part 2 of the Constitution deals with citizenship, which covers Articles 5 to 11. In this chapter, we have to discuss what do we mean by citizenship, what is the significance of citizenship. Then we will look at Indian Citizenship Act of 1955. We'll discuss ways by which an individual can acquire the citizenship of India. We'll also look at the ways by which one can lose his or her Indian citizenship. Then we will discuss concepts such as who was a person of Indian origin, who is an NRI, who is an overseas citizen of India card holder. Then we will discuss Citizenship Amendment Act of 2019. Then we will look at NRC plus NPR plus and link it with the Citizenship Amendment Act. And that would complete our discussion on citizenship. In the last class, I told you that citizenship is normally a matter which is left to the political class, which is left to the legislature, which is left to the parliament to decide. Because rules related to citizenship, laws related to the citizenship may change over a period of time. So citizenship normally as a subject, as a topic, is not mentioned in the Constitution. But I told you the unique circumstances prevailing at the time of the commencement of the Constitution, because the country was divided and partitioned into India and Pakistan, which led to the migration of the millions of people from India to what became Pakistan and from Pakistan to India. And we had to be absolutely sure who are the citizens of India so that we can give them rights, so that we can take care of these individuals. And that is why part 2 of the Constitution deals with citizenship. But listen to me carefully. This chapter, part 2 of the Constitution, talks about who is the citizen of India at the time of the commencement of the Constitution, which is 26th January 1950. That means when the Constitution was enacted, who is the citizen of India? That is something which is mentioned in part 2 of the Constitution. But similarly, Article 11 of the Constitution gives power to the Parliament. The dear Parliament, what you can do, you can pass a law, and through this law, you can regulate all matters related to the citizenship. For examples, Articles 5 to 10, what do they talk about? They talk about who is the citizen of India right now. That means all those who are present in India and who have remained in India for the last 5 years, they become the citizens of India. And this is where July 19, 1948, and sometimes some books also write June 19, 1948. This is the cutoff of citizenship. Cutoff in the sense, prior to this date, whoever was present in India, who has remained in India for 5 years, they are the citizens of India. So the cutoff date is July 19, or some say June 19, 1948. Similarly, these provisions of the Constitution talk about what will happen to those who migrated from India to Pakistan, or what will happen to those who have migrated from Pakistan to India. And these provisions also talk about whoever has acquired the citizenship of another country, these individuals will no longer be the citizens of India. Long story short, Part 2 of the Constitution deals with citizenship. But normally this chapter, this matter citizenship, is left to the political class, is left to the legislature, is left to the parliament. You decide who can or who cannot become the citizens of India. But India was unique because at that time there was a partition, unfortunately on the grounds of religion, which led to the massive migration of people from India to what became Pakistan and from what became Pakistan to India. And we had to be absolutely sure who are the citizens of India. That is why provisions from Articles 5 to 10 deal with who is the citizen of India at the time of the commencement of the Constitution, which is 26 January 1950. Primarily, it means whoever is in India on or before July 19, 1948, and who has remained in India for the last 5 years, you are the citizens of India. If you're migrated to Pakistan, but you want to come back to India before this date, you can become the citizens of India. If you are normally eligible to become the citizen of India because you have remained in India for the 5 years preceding July 19, 1948, but you have taken up the citizenship of another country, you are no longer the citizen of India. So Articles 5 to 10 are not of much relevance now because they deal with who is the citizen of India at the time of the commencement of the Constitution. We'll have to particularly focus on Article 11 because Article 11 gives power to the Parliament that you regulate all matters related to citizenship. And that is how Parliament used Article 11 of the Constitution to pass and enact Citizenship Act. The year was 1955. Clear? Citizenship, as I told you in the last class, all the people who are residing in India, all those who are the residents of India, we can broadly classify them into two broad groups. Either you are the citizens or you are aliens. And this term alien has been derived from a Latin word alienus, which primarily means a stranger, a foreigner. So all those who are residing in India right now, we can categorize them either you are citizens or you are aliens. Who are these aliens? Foreigners. These aliens can further be divided into enemy aliens and friendly aliens, which means citizens of those countries which share cordial, friendly relations with India. If they are present in India, we call them friendly aliens. But if there are citizens of a country with which India is at war, in India, we can call them enemy aliens. And what is the disadvantage of being an enemy alien? That we will discuss in Fundamental Rights chapter. Because specifically, Article 22 is not applicable to enemy aliens. And what is this Article 22? We will discuss in Citizenship chapter. But very briefly here, these enemy aliens can be arrested on mere suspicion as well. And when they are arrested, we don't have to even tell them why you are being arrested. That means we don't have to even tell them the grounds on the basis of which you are arrested, because they are the citizens of those countries with which India is at war. Maybe they will be spy, maybe they will be agents. So the protection which is available to everybody under Article 22. Under Article 22, when you arrest somebody, you have to inform that individual on what grounds you are being arrested. And you have to be produced before the magistrate, before the judge, within 24 hours of your arrest. These protections are available to everybody, whether citizen or foreigner, except these protections are not available to enemy aliens. But these citizens, as I told you in the last class, they enjoy full civil and political rights. Only they have the right to vote. Only they have the right to contest elections. Only they have the right to apply for government jobs, to become judges of the court, to become CAG, to become Chief Election Commissioner. But these aliens, naturally, they do not enjoy all the civil and political rights because they are from a different country. And specifically, these citizens, they enjoy fundamental rights under Article 15, 16, 19, 29, and 30. And these fundamental rights are not applicable to the aliens. Clear? Something else. What is the importance of citizenship? It determines a person's full political membership in the country. So you are a citizen of India, you have the political rights in India. Your permanent allegiance to that country. I owe my allegiance to India. India is my motherland. And at the same time, India should also legally accept me as the citizen. Because there can be hundreds of thousands of people who may claim that they are the citizens of India, but the Indian state has to accept their claim, legally accept their claim that yes, you are the citizens of India. And once the state has accepted that you are the citizens of India, all the civil and political rights are available to you. Which means it is some sort of a symbiotic relationship, give and take, where the state confers rights on the citizens and citizens in return have duties towards the state. It is this beautiful symbiotic relationship that is what we call citizenship. But there is no such concept as dual citizenship. Unlike United States of America. The first discussion that we have had, what is a unitary constitution? What is a federal constitution? And there I told you that we will keep this topic open, whether India is unitary or federal or whether it is quasi-federal. Or there are some provisions in the constitution which are biased in favor of a strong center, which creates a powerful center, more powerful than the states. And what is the phrase that I've used for that? Centralizing tendency of Indian federalism. That means, yes, Indian constitution is federal, but there is a tendency in the Indian constitution where it tilts in favor of a strong center, where it creates center as a powerful entity as against the states. And I told you, whenever we encounter some provisions of the constitution which are biased in favor of the strong center, which gave a centralizing tendency to Indian federalism, I'm going to explain that as well. I'm going to identify those provisions as well. What is the first provision that we discussed, which is biased in favor of a strong center? Can anybody tell me in the comment section? Article 3. What is Article 3? Parliament may by law increase the area of a state, decrease the area of a state, alter the boundaries of the state, change the name of a state, bifurcate a state, trifurcate a state, merge two or more states together. But this is not the power given to the states. This is the power given to the center, Parliament. That means Parliament, the central authority, Constitution has created a strong center where it can divide, bifurcate, merge states. So that is a centralizing tendency of Indian federalism. One more provision which is biased in favor of a strong center, it is this citizenship chapter. Why? Because in United States of America, because what do? When we have to look at any constitution and we have to decide whether this constitution is federal or unitary, what do? We compare this constitution with the Constitution of United States of America. If it matches the US Constitution, it is federal. If it doesn't, then it is something else. One more provision of US Constitution, which gives it a sense that it's a federal constitution, is that they have dual citizenship. What is dual citizenship? You are a citizen of United States of America, but at the same time, you are the citizen of a state to which you belong. Which means you are a citizen of US, you are the citizen of Florida. You are the citizen of US, you are the citizen of Chicago. You are the citizen of US, you are the citizen of Illinois. You are the citizen of US, you are the citizen of any of these 50 states which are part of the United States of America. But that is not the case in India. In India, you are only the citizen of India. You are not the citizen of any state. You may be a resident of Karnataka. You may be a resident of Maharashtra. You may be a resident of Tamil Nadu. You may be the resident of Uttar Pradesh, but you are only the citizen of India. There is no such concept as dual citizenship. And what is this centralizing tendency of Indian federalism? Article 11. What is Article 11? Parliament of India, which is the central legislature, it has been given the power by the Constitution that what you can do, you can define all areas of citizenship. You can make a law through which you can define who are the citizens of India. This is not the power given to the states. Because unlike in United States, the states have their own power, own rules, own laws to decide who are the citizens of their respective states. Who is the citizen of Chicago? Chicago gets to decide. Who is the citizen of Florida? Florida gets to decide. Who is the citizen of California? California gets to decide. But in India, it is the central authority. It is the Parliament of India. It's the central legislature which gets to decide who is or who can become the citizen of India. So one more provision of the Indian Constitution, which gives a sense that it is tilted in favor of a strong center, which is biased in favor of a strong center. That provision is Article 11 of the Constitution, because there is no such thing as dual citizenship. We have only single citizenship. You are only the citizen of India. You are not the citizen of any other state. But there is one more implication of dual citizenship, in the sense that a US citizen can be the citizen of US, can also be the citizen of another country. That means United States recognizes another form of dual citizenship, wherein it says that you can be the citizen of US, you can be the citizen of any other country as well. Dual citizenship. But that's not the case in India. You are only the citizen of India. If you take up the citizenship of another country, your Indian citizenship will be terminated. At the same time, you cannot be the citizen of India, you cannot be the citizen of any other country. We do not recognize dual citizenship. There is only a provision of single citizenship. And this single citizenship also is like a unitary feature of Indian federalism. Unitary feature in the sense, you are only the citizen of India, you are not the citizen of any state. You may be the resident of a state, but you are not the citizen. You are only the citizen of India. And the central legislature, the parliament, gets to decide who is the citizen of India, who is not the citizen of India, who can become the citizen of India, who cannot become the citizen of India. So this citizenship chapter, or single citizenship, is also one of the centralizing tendencies of Indian federalism. But you might ask, sir, why is it that India does not recognize dual citizenship? Why do we recognize only single citizenship? The answer to that question may be that India, or the Indian state, is like a possessive lover. You're only mine, I will not share you with someone else. You're only mine, tum aur kisi ke nahi ho. So maybe that is one of the idea behind single citizenship. You're only the citizen of India. We will not share your loyalty with any other country. Clear? But even then, if you're not clear as to what is citizenship, the beautiful definition of citizenship is given by American political theorist and scientist Hannah Arendt, wherein she writes that citizenship is the right to have the rights. Once you are defined that you are the citizen of India, then you have the right to claim various rights from the Indian state. Rights such as right to vote, right to contest elections, right to apply for government jobs, fundamental rights under Article 15, 16, 19, 29, 30. So citizenship is the right to have the rights. That's what we call citizenship. Now this citizenship, Article 11 gives the power to the parliament that you can regulate all matters related to the citizenship. and Parliament has done that. Passed a law. The year was 1955, and this law has been amended multiple times. And the last time it was amended was in the year 2019. Do you have to remember the dates, the years when the Citizenship Act was amended? No. But keep in mind that this Citizenship Act has been amended multiple times because we have had questions in the prelims exam in the past. For example, a statement was given in one of the prelims examination. The Office of Profit Law has been amended twice in India. So you have to remember, you have to keep in mind that this Citizenship Act, it has been amended multiple times. It was passed in 1955, but it has been amended multiple times. The last amendment was in 2019. But this Citizenship Act is an ordinary law. And ordinary laws, we have discussed, can be enacted, can be passed by the Parliament by simple majority. Because what is the supreme law? The supreme law is the Constitution. And if you have to change the Constitution, amend, modify, alter the Constitution, for that, what is the type of majority required? Special majority. But Constitution has given the power to the Parliament that you can make a law, and through this law you can regulate all matters related to the citizenship. And when Parliament passes such a law is known as an ordinary law. And this ordinary law is passed by simple majority. So the Citizenship Act, which was passed in 1955, it is an ordinary law passed by simple majority. And if you have to make any changes to this law, these changes can also be made by simple majority. That is how CAA 2019 was passed by simple majority. Clear? Now let's look at what is the Citizenship Act of 1955. What does it talk about? Acquisition of Indian territory. Who can acquire the citizenship of India? And what does it talk about? The loss of Indian citizenship. How can one lose the citizenship of India? Is that clear? If that is clear, let me know, then we will start. Why simple majority, sir, not Article 368? Article 368 is used to amend the Constitution. Here we are passing a law, an ordinary law. Because when Constitution has given the power to the Parliament that you make a law to decide who can become the citizen of India, Parliament passes this ordinary law by simple majority. You're not making changes to the Constitution. You're not making changes to Article 11. If, for example, Article 11 gives power to the Parliament that you can regulate all matters related to citizenship. If Parliament wants to alter Article 11 and say Article 11 confers power on the Parliament as well as state legislature to decide who can become the citizen of India. So you are changing Article 11. This change in Article 11 requires Article 368, requires special majority. But you are not changing Article 11. Article 11 says, Parliament, you regulate matters related to citizenship. You pass a law. So when Parliament has been given power by the Constitution, Parliament enacts a law by simple majority. Okay, clear? Shall we start? Perfect. Now, there are 5 ways by which one can acquire the citizenship of India. By birth, by descent, by registration, by naturalization, by incorporation of the foreign territory. We will now discuss what are these 5 ways by which one can acquire the citizenship of India. First is by birth. And listen to me carefully. this provision has been changed multiple times. And I will tell you what was the position of this provision before 1987, then between 1987 to 2003, then 2003 onwards. By birth. This is where we'll have to understand two concepts, jus soli and jus sanguinis. Jus soli means law of the soil. Jus sanguinis means law of the blood. What does that mean? For example, in United States of America, they follow a concept called jus soli, law of the soil. Whoever is born on the soil of United States of America, that person is the citizen of India. That child is the citizen of India. Regardless of the nationality, regardless of the citizenship of their parents. That means parents may be from China or Germany or Japan or any other country, but the child born to a German parent or a Japanese parent or a Chinese parent on the soil of United States of America, that child automatically becomes the citizen of the United States of America. Because what do they follow? They follow law of the soil. Whoever is born on the soil of United States is the citizen of India. And soil also means the territory of United States. Territory of United States includes the air above the United States territory. You also are part of the territory of United States. For example, few years ago, there was a lady from Hong Kong traveling in a plane, but she was pregnant. She was expecting, and she was 9 months pregnant. And suddenly when the plane is traveling and cruising towards United States of America, she started labor. Now there are passengers who are trying to help her, but she is refusing help. She is asking a question, have we entered the US airspace? Because if we enter the US airspace, it is part of the territory of the United States of America. She was told, no, we have not yet entered the US airspace. She said, please wait. And once this plane entered the US airspace, which is the territory of United States, which is the soil of United States, the child was born. And this child automatically became the citizen of the United States of America. Which means the principal objective of this lady was that the child should be born on the soil of United States of America, which includes the airspace of the United States of America, so that automatically this child becomes the US citizen. So in United States, what do they follow? Jus soli, law of the soil. Whoever is born on the soil of United States automatically becomes the citizen of United States. And the same provision was there in Indian law before 1987. Before 1987, whoever was born on the soil of India, regardless of who your parent is, what is the nationality of your parent, is your father an Indian or a mother an Indian, doesn't matter, the child born on the soil of India before 1987 automatically becomes the citizen of India by birth. But then in 1987, this law was changed. Citizenship Act was changed. And according to the changed provision, we shifted from jus soli to jus sanguinis. Jus sanguinis in the sense, this child who is born on the soil of India by birth can become an Indian citizen if one of the parent is an Indian. Initially, there used to be a sexist provision in the law where only if the father is an Indian, then the child could become an Indian. Later on, it was changed and said, whoever is born on the soil of India, and if one of the parent is an Indian, no matter who the other parent is, other parent can be anybody. If one of the parent is an Indian, you are the citizen of India by birth. That means we changed and we shifted from Yas Soli, law of the soil, to Yas Sanguini, law of the blood. If you're born on the soil of India, but by blood you're related to an Indian, one of the parent is an Indian, only then can you be the citizen of India by birth. But then when one of the parent is an Indian, other parent can be anybody, can be a foreigner as well, can be an illegal migrant as well. Illegal migrant in the sense, I told you a couple of classes ago, who is an illegal migrant. For example, if I'm from Bangladesh, I'm the citizen of Bangladesh, I have to come to India. How do I travel to India? I approach the Indian embassy in Dhaka or a consulate in some city and then apply for visa. Let's say the visa is valid for a month. And if I travel to India on this valid legal document known as the visa, but this visa is valid for a month. If I overstay, that means if I stay for more than a month, that means I become an illegal migrant in India. That means legally I could have stayed in India for only a month, but now I am overstaying. Now I become an illegal migrant. And then if I marry an Indian, the child born will also be an Indian because one of the parent is an Indian. Forget about the other parent. Other parent may be an illegal migrant, but the child is an Indian. Similarly, there is another illegal migrant. I come from Bangladesh, but I sneaked into India without any visa. Forget about passport, forget about visa. I sneaked into India, and then when I enter India, I also marry an Indian. Now the child is born. This child is the citizen of India. Why? Because one of the parent is an Indian. Although the other is an illegal migrant, can be a foreigner as well, but the other parent is an Indian, this child is an Indian. Then the government realized that we are then legalizing illegal migration in India. We are allowing people to illegally migrate in India, marry an Indian, and then these children born will also become the citizen of India by birth. That is how 2003 the law was changed again. The law said the child born on the soil of India can become an Indian by birth if both the parents are Indians, the child is an Indian. If one of the parent is an Indian, the child is an Indian. If one of the parent is an Indian and the other parent is not an illegal migrant at the time of her birth. So when the child was born, if at that time one of the parent was an illegal migrant, this child cannot become the Indian citizen by birth. So what are the ways by which one can acquire Indian citizenship? One is by birth. And for that, we have to remember different points of time. Before 1987, doesn't matter who your father or mother is. If a child is born on the soil of India before 1987, the child is an Indian. Done and dusted. Second, now the condition is, after 2003, if a child is born on the soil of India, this child can become the citizen of India only if both the parents are Indians, only if one of the parent is an Indian and the other is a legal migrant. If the child is born on the soil of India, where one of the parent is an illegal migrant, this child cannot become the Indian citizen by birth. So one way by which we can acquire Indian citizenship is by birth. Clear? Perfect. The second is by descent. Descent means you are the citizen of India, applied for the civil services examination, qualified this examination, became an Indian Foreign Service officer. And as an Indian Foreign Service officer, you are now posted in United States of America. And in United States of America, you fell in love with a US citizen and you got married. Now the child is born. Can this child also become the Indian citizen? Yes. How? Through blood link, through descent. Because one of the parent is an Indian. Because suddenly you watched Swades, Shah Rukh Khan, ye jo desh hai mera. I don't want to leave my country. I want this child to also become the Indian. So even this child is born outside the territory of India, in United States of America, for example, all you have to do, you have to approach the US Embassy, Indian Embassy in United States, or an Indian consulate in United States. And you will have to register the birth of this child within 1 year. One year in the sense, the child is born not within the territory of India, not on the soil of India. So this child cannot become the citizen of India by birth, because the child is not born on the soil of India, but the child is born outside the territory of India, but to an Indian parent. Maybe both the parents are Indians, or one of the parents is an Indian. This child, who is related to India by blood through descent, this child can also become the Indian citizen, provided the parent registers the birth of this child within 1 year of his birth at an Indian embassy in United States. So by descent, you can become the citizen of India. But listen to me carefully. What did I tell you about United States? That they follow dual citizenship. What is that dual citizenship? Two implications. One implication is you are the citizen of United States, you are also the citizen of Florida or Chicago or Michigan or Illinois. Clear? Or you are the citizen of United States, you can also be the citizen of any other country. But in India, we do not follow dual citizenship, we follow single citizenship, which primarily means that you are only the citizen of India, you are not the citizen of any other country. But what about this child who is born to an Indian parent outside India, let's say in United States of America, let's say in a country which values, recognizes dual citizenship. So this child who is born to you in United States of America, this child is born in US, so automatically this child becomes a US citizen, because they follow the concept of Yas Soli, law of the soil. Whoever is born on the soil of United States of America is the US citizen. But this child who is born to an Indian parent is a US citizen by birth, but can also become the Indian citizen by descent. If you registered the birth of this child in a Indian embassy or an Indian consulate, now only for this child there is dual citizenship. Only for this child there is dual citizenship. That means this child can become the citizen, can remain the citizen of both India as well as United States. But till this child completes the age of 18. Once this child has completed the age of 18, then within 6 months, this individual who is now a major, who is now an adult, has to decide whether you want to continue as the US citizen or Indian citizen. So you have to give up one citizenship, either US citizenship or Indian citizenship. If you give up US citizenship, then you continue as the citizen of India. Otherwise, you're only the citizen of United States, because after 18 years, we cannot value your dual citizenship. Which means, what are the ways by which one can acquire Indian citizenship? One is by birth. And what do we mean by birth? The child born today, after 2003, for example, today in 2023, the child born on the soil of India can become the citizen of India if one of the parents is an Indian or both parents are Indians and one parent is not an illegal migrant. By birth is clear? Done. By descent, you are born to an Indian but not on the soil of India, outside India. This child born to an Indian parent or Indian parents outside India can also become an Indian through descent. All the parents have to do, they have to register the birth of this child within 1 year of his or her birth. This child becomes an Indian citizen as well. But what if this child is born in a country which recognizes dual citizenship, which recognizes Yas Soli, for example? Whoever is born on the territory of United States automatically becomes a US citizen. So this child is a US citizen by birth. is an Indian citizen by descent as well. Only this child who is born outside the territory of India, only this child is allowed to have dual citizenship, but only till this individual completes the age of 18. Once you become 18 years old, you become an adult, then within 6 months, you have to decide whether you want to continue as the citizen of India or you want to continue as the citizen of United States. And within 6 months, you have to take a call. This is what we call citizen by descent. Any questions? Okay. The third is by registration. And there are different categories of people who can become Indian citizens through registration. We will discuss some other categories slightly later, but one category we will discuss today. We'll discuss now. And before we discuss that, let me tell you very frankly, by reading citizenship chapter, by attending this lecture, please don't come up with permutations and combinations. Sir, what will happen if I travel to United States, then I marry somebody, then we want to come back, then we want to go back? There can be hundreds and thousands of permutations and combinations. But here in civil services examination, on this chapter, numericals will not be asked. Numericals will not be asked. So you don't have to worry about these permutations and combinations. Just understand the concept. By registration, for example, Srimati Sonia Gandhi. Was she born on the soil of India? No. So she is not a citizen of India by birth. Was she born to an Indian parent outside India in Italy? No. That means she is not the citizen of India by descent. But who is she? She fell in love with an Indian, married an Indian, came to India, settled in India. Now she can also apply for Indian citizenship. Through which route? The route is registration. What is this registration? Srimati Sonia Gandhi, you love Rajiv Gandhi. Now you have got married. You are now staying in India. You ensure that you're staying in India for 7 years. If you stay in India for 7 years, after 7 years, you are eligible to become an Indian citizen. But not through birth, because you are not born on the soil of India. Not through descent, because you are not born to an Indian parent outside India. But you can apply for Indian citizenship by registration. You can register to become the citizen of India because you are married to an Indian and you have stayed in India for 7 years. 7 years in the sense, that means your intention is to reside in India permanently. Your intention is to reside in India for a long time. Now you can become an Indian citizen through registration. There are various other categories of people who can also apply for Indian citizenship through registration. We will discuss it slightly later. Here, just keep in mind that if the route is not through birth, if the route is not through descent, then the route to Indian citizenship is via registration. Clear? 100%? For example, here is this individual, this child, who was born outside the territory of India, but to an Indian parent. So you are basically an Indian if your birth has been registered within 1 year of your birth. But for example, at the time of 18 years, once you complete 18 years, you decide, no, I will continue to be the US citizen. I will not take up Indian citizenship. And now for 20 years, 30 years, 40 years, you are the US citizen. But now suddenly one day, one fine evening, you are bored, you turn on your TV or you turn on your Netflix and you look at Ashutosh Gowarekar's Swades. And suddenly your eyes well up and you want to come back. You can come back. Can you become the citizen of India? Yes. Through which route? Through registration now. That means if you come back, you stay in India for 7 years, you can become an Indian citizen through registration. This is another category, another group of people who can apply for Indian citizenship through registration. Clear? Perfect. Now there is another category by naturalization. For example, Mother Teresa. She was not born in India, nor born to an Indian parent outside India, nor was married to an Indian, nor was once eligible to become an Indian citizen and decides to come back. But she loved this country and she wanted to become an Indian. Is there a route for such individuals to become the citizen of India? Yes, by naturalization. Adnan Sami, for example, the latest case of Indian citizenship through naturalization. Adnan Sami was not born in India, was not born to an Indian parent outside India, is not married to an Indian as well, was not ever eligible to become an Indian citizen, but he loved this country, stayed in India for a long time, and applied for Indian citizenship. Through which route? Through naturalization. But there are some conditions which you have to fulfill to become an Indian citizen through naturalization. Just like there are conditions that you have to fulfill to become an Indian citizen through registration. You have to stay in India for 7 years if you're married to an Indian. You have to stay in India for 7 years if once you were the citizen of India, but then you gave up the citizenship and you became the citizen of another country. Similarly, there are some conditions that you have to fulfill in order to become an Indian citizen through naturalization. What are these conditions? Number one, you should not be from a country where Indians are not allowed to become citizens. That means if you want to become an Indian citizen through naturalization, but from which country do you come from? You should not come from a country where Indians are not allowed to become citizens. For example, if you are from Saudi Arabia, where Indians are not allowed to become citizens. In fact, foreigners are not allowed to be citizens of Saudi Arabia at all. And if you are from Saudi Arabia, you cannot become the Indian citizen through naturalization, because Indians are not allowed to become the citizens of those countries. Number one. Second condition, you should also give up your previous citizenship. If you are from Bulgaria, if you are from China, for example, or if you are from Pakistan, for example, and if you want to come to India, you want to become an Indian citizen through naturalization, you have to give up your previous citizenship as well. Why? Because we do not recognize dual citizenship. That means you cannot be the citizen of India as well as any other country at the same time. You have to give up your citizenship. Now you might say, sir, what if I give up my US citizenship? Then I come to India, I apply for Indian citizenship through naturalization. And after some time, the government of India says, no, you cannot become the citizen of India. I am neither here nor here. I gave up my US citizenship. Now India is not giving me the citizenship. I am in a no man's land. There is no country for me, no country for old men, for example. Then what will I do? It's not that first you have to give up your citizenship, then you have to apply for Indian citizenship. It is that you can be the citizen of any other country as well. Then you apply for Indian citizenship. Once Indian citizenship is given to you, granted to you, you have to give up your previous citizenship. That means the moment you become an Indian, you have to give up your previous citizenship. That's another condition. Another condition is that you should have resided in India for 14 years. 14 years in the sense, if you have come to India in the year 2000, you can apply for Indian citizenship through naturalization only in 2014. Why? Because you should have stayed in India for 14 years. That's how we will come to know that you are genuinely interested in becoming the citizen of India. That doesn't mean you're illegally staying in India for 14 years. That means you're on a valid visa. You keep on extending your visa. Indian government keeps on extending your visa. Your visa is extended. You are a migrant in India, legal migrant in India, because with a valid visa, you are staying in India for more than 14 years. And after 14 years, you can apply for Indian citizenship through naturalization. But sir, does that mean that in all these 14 years, this person should have never left the country? If I have come to India in 2000, does that mean for 14 years, next 14 years, I should have never left this country? I should have continuously stayed in India for 14 years? No. Out of these 14 years, you should have stayed in India for 11 years. 11 years in the sense, you entered India in 2000. And in 2014, you can apply for Indian citizenship. Does that mean for all these 14 years, you should have never left this country? No. That means you may have left this country as well for travel, for business, for any other reason. But when we calculate the number of days you were in India, all the days when we calculate that you were in India, if it adds up to 11 years, that means in the last 14 years, if you were staying in India for 11 years, you become the citizen of India, or you become eligible to become the citizen of India through naturalization. Another condition, you should have the knowledge of any of the languages mentioned in the 8th schedule of the Constitution. We have discussed first schedule, names of the states and union territories. We have discussed 4th schedule, where we talked about representation of states in the Rajya Sabha, how many seats from UP will be there in Rajya Sabha, that's mentioned in Schedule 4. Similarly, there is Schedule 8, which talks about 22 Indian languages: Hindi, Marathi, Kannada, Tamil, Odia, Nepali, Sindhi, Dogri, Kashmiri. 22 languages are mentioned in the 8th schedule of the Constitution. And if you want to become an Indian citizen through naturalization, it basically means that you should have the knowledge of any language mentioned in the 8th schedule of the Constitution. And your intention should be to reside in country for an indefinite period, for a permanent period. You're not a fly-by-night operator that you will get Indian citizenship and run away. So what are the ways by which one can acquire the citizenship of India? One is by birth. Clear? The other is by descent. The other is by registration. The other is by naturalization. For example, Adnan Sami was given the citizenship of India through naturalization because he was not born in India. He was not born to an Indian parent outside India. He was not married to an Indian. But now he still wants to become an Indian citizen. So what you have to do, you have to fulfill some conditions. Conditions such as, you should not be from a country where Indians are not allowed to become citizens. You should have the knowledge of any of the language mentioned in the 8th schedule of the Constitution. You should also have the potential, or should have ordinarily resided in India for 11 of the last 14 years. But what about Adnan Sami? In a sense, he's from Pakistan. His father was a pilot, Pakistani Air Force pilot, who played an important role in the 1965 war between India and Pakistan. So how can we provide citizenship to this Pakistani? Because in Pakistan also, Indians are not allowed to become citizens. This is where there is an exception. What is the exception? In all matters related to the citizenship, there is one ministry which is responsible. And that ministry is the MHA, Ministry of Home Affairs. So Ministry of Home Affairs is the ministry responsible for all the citizenship matters. And what MHA can do, it can waive off. Waive off in the sense, for example, there is a talented student who has to pay a fee to the university or to the college. The fee is 20,000 rupees. But if you belong to a weaker section of the society, your fee can be waived off. That means you don't have to pay the fee. Or for example, if you have taken a loan and you are a farmer, loans for farmer can be waived off. For example, if the government decides that loans for the farmers are waived off because that's the demand by the farmers from different states, That means although you applied for loan was given, you don't have to repay that loan. We have waived off your loan. Similarly, if there is an individual who has performed spectacularly well, who has contributed immensely in the field of art, in the field of literature, in the field of science, in the field of human progress, in the field of world peace, this individual, if he or she wants to become the citizen of India through naturalization, the Ministry of Home Affairs may waive off all the requirements required in order to become the citizen of India, except one. You have to give up the citizenship of your previous country. You cannot be dual citizenship holder. Apart from this, any other criteria can be waived off. In the sense, you are not residing in India for 14 years, doesn't matter. You can still become an Indian citizen through naturalization. Why? Because you belong to a category which has performed well in the field of art, literature, human progress, science, world peace, and we are waiving off all requirements required in order to become the citizen of India through naturalization. That means central government may waive all or any of these conditions for naturalization in case the person has rendered distinguished service in the field of science, philosophy, art, literature, world peace, or human progress. And every naturalized citizen must take an oath of allegiance to the Constitution of India. So when the then Home Minister, Shri Rajnath Singh, gave the citizenship certificate to Adnan Sami, he also was administered oath. I owe my allegiance to the Constitution of India. So what are the ways by which you can acquire Indian citizenship? By birth, by descent, by registration, by naturalization, and the fifth is by incorporation of a territory. For example, Goa was acquired. Goa was not part of India. Goa was acquired, now is part of India. So what will happen to those who are residing in Goa? The central government will specify who are these citizens of Goa, residents of Goa, who can become the citizens of India. If Sikkim became part of India, the government of India will decide who all from Sikkim can become the citizens of India. That means when you incorporate a foreign territory, that does not mean automatically all their residents automatically become Indian citizens as well. No, the central government will specify who are these individuals in that territory which has been incorporated. Who are these who can become the citizens of India? For example, tomorrow, if we acquire Pakistan, if Pakistan also becomes part of India, that doesn't mean all the citizens of Pakistan automatically become the citizens of India. No. The central government, which is the MHA, the Ministry of Home Affairs, will specify who all from Pakistan can become the citizens of India. That means we may not want Imran Khan to become the citizen of India, Hafiz Saeed Masood Azhar to become the citizen of India, General Bajwa to become the citizen of India. We may want Babar Azam, who plays well. We may want all the fast bowlers of Pakistani cricket team or their hockey team members, all the artists of the Coke studio to become the citizens of India. But those terrorists, those miscreants, we may leave them. They are not the citizens of India. So there are 5 ways by which one can acquire the citizenship of India: by birth, by descent, by registration, by naturalization, by incorporation of the foreign territory. If you have any questions, let me know. Who is Adnan Sami? Adnan Sami is an artist, a singer, one of the fastest piano players in the world, a musician as well. Does not hold password. Where is it mentioned password? I have not mentioned password anywhere. Passport. Sir, what is 14 years and 11 years point? I missed it. I want to become an Indian citizen through naturalization because I cannot become the Indian citizen through other route because I was not born in India. I was not born to an Indian parent outside India. I was not married to an Indian as well, but still I want to become an Indian citizen. For example, John Drays, Professor John Drays, who frequently writes in the Indian Express, the Hindu, not an Indian by birth or descent or registration, but an Indian by naturalization. Mother Teresa, Adnan Sami, you have to stay in India for 14 years. Let's say 2000 till 2014. You entered India in 2000, you stayed in India till 2014, you are eligible to apply for the citizenship of India through naturalization. But that doesn't mean in all these 14 years, you should have never left this country. I may have left India for business, tourism, any other purpose, medical purpose. But when we calculate the number of days you were in India in the last 14 years, in India, you were here for the last 11 years. You are eligible for citizenship. Shalu is asking, sir, please check descent slide. Where is password mentioned? I have to use password to see password. Where is password? It's passport, my dear. Any other question, please? Then we will jump to another part. Any child who is born in the air of India, what will be his or her citizenship? If the child is born within the territory of India, which includes the airspace, we'll have to look at conditions of birth. If one of the parent is an Indian, the other is not an illegal migrant, the child is an Indian. Please repeat incorporation. You are incorporating Pakistan as the territory, as this state of India or part of the territory of India. But all those people who are residing in Pakistan, will they automatically become the Indian citizens when Pakistan becomes part of India? No. Central government will specify who all of these people can become the citizens of India, who cannot. Sir, after 18 years, how many time one needs to register? Shiva, I think you're asking about that child who had a dual citizenship, but he gave up Indian citizenship at the age of 18. After how many years can he apply for Indian citizenship? He can apply any time, but for that he has to stay or she has to stay in India for 7 years. If you have stayed in India for 7 years, you become the citizen of India. Civil rights, for example, the right to get jobs, right to educational opportunities, those are civil rights. Okay. Now, if there are 5 ways by which one can acquire Indian citizenship, by birth, by descent, by registration, by naturalization, by incorporation of the foreign territory, and this clause by registration, we will discuss more slightly later. So bear with me. There are 3 ways by which one can lose the citizenship as well. Which are these 3 ways? One is by renunciation. Renunciation is a voluntary act. This is how lakhs of individuals every year, they lose their citizenship. How? Voluntarily. Indians travel abroad, for example, to United States or Germany or Australia or New Zealand or France or United Kingdom, and they are settled there. They don't want to continue as the Indian citizens. They voluntarily give up their Indian citizenship. When they voluntarily give up their Indian citizenship, that means they have renounced their citizenship. And when you have renounced your citizenship, that means you are no longer the citizen of India. For example, Akshay Kumar is not the citizen of India. He is the citizen of Canada because voluntarily he has given up his Indian citizenship. So he is not the citizen of India. He is the citizen of Canada because he has given up voluntarily his Indian citizenship. Clear? So one way by which you can lose your citizenship is by renunciation, voluntary act of giving up your Indian citizenship. Now listen to me carefully. Here is an individual and the partner, for example, husband and wife. They have minor kids. Minor kids in the sense, less than the age of 18. Now both the parents, they give up Indian citizenship. What will happen to their minor kids? They will also lose their citizenship. So if you are from India, both the parents are Indians, but now the child is born on the soil of India, this child is an Indian by birth. Now what happens? The entire family travels to Canada, for example, and there they decide to give up their Indian citizenship. But what will happen to these minors? Their citizenship also is gone. They are also not the citizens of India. But if, for example, mother and father and their minor kids, mother and father give up their citizenship, these minor kids, they also lose their citizenship. Now they are studying in Canada, having interaction with the Canadian citizens, students, and over a period of time, again, once they cross the age of 18, they watch Swades movie, they want to come back. Then what will they do? They will first question their parents, how dare you give up our citizenship? We want to go back to India. We love the Indian food, culture, cuisine, everything. And now these kids, they want to come back, who are now major, who are now adults. They want to come back. Can they become Indian citizens again? Yes. How? Through registration. Registration in the sense that they were once the citizens of India. Now they have given up their Indian citizenship. If they want to come back, all they have to do, come back, stay in India for 7 years, and after the end of 7 years, they can also become the Indian citizens through registration. Because now they are registering to become the citizens of India. So what is renunciation? Voluntary act of giving up your Indian citizenship. And that is happening every year, every day, where hundreds of Indians, they voluntarily give up their citizenship. Renunciation. Does Jammu and Kashmir people have dual citizenship? No. They used to have prior to the special status, prior to August 5, 2019, but no longer now. There also we have single citizenship. Maithili, what is your question? She has an allegation that queries are answered only for Shalu. Now, it doesn't matter who the student is. I don't even check the name of the student. I just look at the question. So I'm sorry if you feel I'm biased, but I think I'm not. Can one be an Indian citizen again after giving up his citizenship? Yes, you can come back and you can apply for citizenship through registration. So you can become the citizen of India again by registration. Second is by termination. What is termination? You are an Indian citizen, but then you travel to United States of America, and there you apply for the citizenship of United States without renouncing your Indian citizenship. That means you are an Indian citizen, you travel to United States of America, there you apply for US citizenship, you get the US citizenship as well, but you have not given up your Indian citizenship because you can't have dual citizenship. Now the central government, when it realizes, when it comes to know that here is an Indian citizen who has shared the loyalty now, he is the citizen of India as well as any other country as well, but he has not given up his Indian citizenship. The central government will terminate his or her citizenship. That means termination is done when a citizen of India voluntarily acquires the citizenship of another country, but this individual has not given up, renounced his Indian citizenship. So what are the ways by which one can lose Indian citizenship? By renunciation, which is a voluntary act. I don't want to continue as the citizen of India. I want to give up my Indian citizenship. I have renounced it. Second is by termination, which means you have acquired the citizenship of another country without giving up, without renouncing your Indian citizenship. Government comes to know, the government will terminate your citizenship. That is termination. And the third way by which one can lose citizenship is by deprivation. What is deprivation? For example, here we have a citizen who has become an Indian citizen through naturalization or registration. Listen to me carefully. If you are an Indian, your citizenship, you can give up your citizenship, which means you can renounce your citizenship. And if you have acquired citizenship of another country, without giving up on your Indian citizenship, your citizenship can be terminated. After that, if you have neither renounced it, nor have you acquired citizenship of another country, your citizenship cannot be deprived from you. But what about these individuals who become Indian citizens through naturalization or registration? But I've told you that in order to become citizens of India through naturalization or through registration, you have to meet certain conditions. You have to meet certain requirements. What if you have acquired citizenship of India through registration and naturalization, but through fraud, through false representation, through concealment, you are hiding some of the material facts, your citizenship can be deprived from you. Deprived in the sense, you can become an Indian citizen by registration, provided, for example, one condition is you are married to an Indian. So you showed that I am from Germany, but I'm married to an Indian. Now I've stayed in India for 7 years. Give me Indian citizenship. This citizenship was given to you. But then central government realized that you were never married to an Indian. That means you have acquired Indian citizenship through registration, but through fraud. You have committed fraud. Your citizenship can be deprived from you. Second, in order to become the citizen of India through naturalization, for example, you have to meet certain conditions. Conditions such as you should have ordinarily resided in India for 11 of the past 14 years. That means if you have applied for Indian citizenship today, now we will look at your previous 14 years. Out of these 14 years, you should have stayed in India for 11 years. What if you are giving false documents to prove that you were in India for the last 14 years? That means through false representation, you have acquired citizenship through naturalization. Your citizenship can be deprived from you. Which means if there is an Indian citizen, not by birth, not by descent, not by the incorporation of the foreign territory, but you are an Indian citizen through registration or naturalization. But the central government realizes that you have acquired citizenship by registration, acquired citizenship by naturalization through fraud, through false representation. You have been hiding some of the facts. Then your citizenship can be deprived from you. And later on, you may never be able to apply for Indian citizenship again. That's deprivation. Similarly, if you are disloyal to the Constitution, if you are an Indian citizen through registration or naturalization, but over a period of time, you are disloyal to the Constitution, violating the Constitution, abusing the Constitution, your citizenship can be deprived. Or you are an Indian, but you are remaining outside India continuously for the last 7 years. That means continuously for the last 7 years, you have not come back to India. You have not returned back to India. then your citizenship can be deprived. You are deprived of your Indian citizenship. That means if there are 5 ways of acquiring Indian citizenship, which is through birth or descent or registration or naturalization or by incorporation of a foreign territory, 5 ways by which you can acquire Indian citizenship, there are 3 ways by which one can lose citizenship as well. Which are these 3 ways? By renunciation, which is a voluntary act, I am voluntarily giving up my Indian citizenship, or through termination, which is you are an Indian, but at the same time you have acquired the citizenship of another country. Without giving up your Indian citizenship, your citizenship will be terminated. Or deprivation. Deprivation for those who have acquired citizenship through registration and naturalization. And if the central government, which is the Ministry of Home Affairs, if it gets to know that you have acquired Indian citizenship through naturalization and registration, but through fraud, through false representation, through concealment of facts, your citizenship can be deprived. And what about other Indians? Any Indian, even if you're a citizen by birth, naturalization, registration, descent, incorporation of a foreign territory, if you have remained outside India continuously for the last 7 years, your citizenship can be deprived. But this doesn't apply to those who are the students of foreign universities or those who are the government employees but working outside, for example, foreign officers working outside. This 7-year clause does not apply to them. That means students can remain outside India for 7 years as well. Their citizenship cannot be deprived. Government employees posted by Government of India outside, they can remain there for 7 years. Their citizenship cannot be deprived. Similarly, there can be Indian Army officers or Indian Armed Forces personnel who may be posted in Sudan on UN peacekeeping missions, because United Nations, whenever there is a turmoil in a particular country, they bring in police or army from different countries and posts them in these troubled areas. Indians have also contributed to UN peacekeeping missions. And if there is an individual, a member of the armed forces, who is on a peacekeeping mission at some another country continuously for more than 7 years, your citizenship cannot be deprived. These are the 3 ways by which one can lose citizenship. Any questions? Let me know, then we will jump to another part. What if one stays in Saudi Arabia for 7 years? Does he lose his citizenship? Staying in Saudi for 7 years and staying continuously outside India for 7 years is different. If you're staying in Saudi for 7, 8, 10, 20 years, but every year you come back, or every few years you come back for a few days and then return, you will not be deprived of your citizenship. How does Indian government know that these or that person has citizenship of 2 countries? The government knows everything. If both parents are foreigners but child was born in Indian air, is that baby called an Indian? What did I tell you? The child born today on the soil of India becomes an Indian if one of the parent is an Indian. So condition is, yes, sanguine. Necessarily one of the parent has to be an Indian. Again, don't come up with these permutations and combinations. Sir, what if today we went abroad, then we want to come back, then we want to go back? What will happen to our kids? These permutations and combinations will not be asked in the exam. Manta says, sir, I need break. Please take break. Who stops you? Close the lid, go. But I will not give the break now. So then how is Akshay Kumar living in India if he is not a citizen of India? My dear, can you not see foreigners staying in India? They are on a valid visa in India. Are there no foreigners in India? There are foreigners in India. Every in every city, in every part of this country, maybe for education, maybe for employment. They're working in private sector in large numbers. So if we can't stop them, why do we stop Mr. Kumar? He's also paying tax in India. So then why is he doing nationalist movies? Ask him. I'm not giving him any movies. I'm not writing scripts for him. Focus on the civil services exam, my dear. Forget about what Arnab Goswami says or what social media says. Stick to your syllabus, complete it, clear the exam, then you have all the time in the world to discuss these things. Sir, what about citizens through descent giving false representation? False representation is for those who apply for citizenship through naturalization or registration, not for descent. How can you give false representation in descent? Because both the parents are Indians or one of the parents is an Indian. Okay. Now let's look at what's the difference between PIO, which is person of Indian origin, and OCI, which is overseas citizen of India. Now for that, we need to understand diaspora. What is diaspora? Diaspora is one of the important agents of India's soft power. What is soft power and what is hard power? For example, India and Russia. We have to control Russia or control its government's policy or impose our own priorities on the Russian government. How do we do that? Through hard power, through force. That means send military to Russia, control their government, or impose threats to the Russian government that you have to do this, send us S-400 defense system, otherwise we will kill you. That means through your military power, through your military might, you might want to get favorable results from that country. But instead of using hard power, there is another way. Use the soft power. What is the soft power? For example, Indians. Now they decide to migrate from India and travel to other countries of the world, and there they acquire Indian citizenship. There they acquire their citizenship. So who are these individuals? They are part of diaspora. That means they have Indian connection. They were once the citizens of India. They were once linked with India, but now they are the citizens of other countries. They will still have some element of honesty, faith, respect, love, affection for India. For example, Microsoft head, the Google Alphabet head, previously Twitter, and look at the number of Indians who are also the prime ministers of different countries. We have had Mauritius Prime Minister who has an Indian connection. If you can call Mr. Rishi Sunak with Indian connection, that's also valid. So individuals who were Indians, but now they are citizens of other countries. And now in these countries, they are in the positions of power, maybe top businessmen, top technicians, top technocrats, top politicians as well. Now they will persuade their governments to have good relations with India. That's what we call soft power. For example, Bollywood or Hindi cinema or the Telugu cinema, Tollywood now, or the regional cinema, it can act as India's soft power. Why? Because it is argued that one individual who is responsible or who has played a very important role in bringing India and Russia together, closely together, that individual is Shri Raj Kapoor, the original showman, who went to Russia and shot various movies, various scenes in these countries, and ultimately India and Russia relationship got strengthened. This is what we call soft power, and that is what Minister for Information and Broadcasting, Shri Anurag Thakur, also said recently. We don't agree with this boycott culture. Don't boycott movies, because these movies act like India's soft power. It is through these movies that, let's say, Shah Rukh Khan is the global superstar from India. Everywhere, Shah Rukh Khan is known as an Indian. So Shah Rukh Khan has an influence in various countries. That means diaspora plays a very important role. And these members of diaspora, they have ensured, they have helped to a large extent to have good relations between their countries and India. PIO and OCI, the year was 2000 when Ministry of Home Affairs decides to launch a scheme known as Person of Indian Origin. Who is a person of Indian origin? Any person who at any time held Indian passport. That means I was once an Indian, I held an Indian passport, now I'm not the citizen of India, I am the citizen of United Kingdom, I am the citizen of United States, I am the citizen of Germany. If I want, I can apply for this card under PIO scheme, Person of Indian Origin scheme. What will happen because of this? If I have the PIO card, I can come to India without any visa for 15 years. That means normally what happens? If you are a foreigner and you want to come to India, you have to apply for visa. You have to apply for visa. It takes some time as well. And visa can be given for specific reasons, for medical reasons, for health, education reasons, for tourism reasons. But these members of other countries, but they once held Indian passport, so they have a connection with India. They are basically part of the diaspora. We basically want to ensure that they seamlessly come to India. How? Because they also send remittances. Remittances in the sense, anything which brings dollar to India, to Indian economy, is better for us, is the best structured for us. There is an individual who has now acquired the citizenship of another country, well, US citizen, but still he sends or she sends money to his family members in India or to their extended family members in India. So you are remitting money, you're sending money back to India in the form of dollars. So what are these diaspora members doing? They're still helping India to grow by sending dollars to India. And can't we do a simple thing for them? That when you want to come to India, you come to India without any visa for 15 years. So once you have applied for PIO card, for the next 15 years, you can come to India any number of times, any number of years without any visa. Similarly, when a foreigner comes to India, he or she has to report before the police, Foreign Registration Office, FRRO. You have to report to the police, you have to report to the FRRO. Now the PIO scheme said, if there is a person of Indian origin, somebody who once held Indian passport, if he or she wants to come to India, if your stay in India is for less than 6 months, don't report to the police. You have no requirement to approach the police. But if your stay in India is for more than 6 months, then yes, you'll have to report to FRRO. Which primarily means some kind of benefit was given to these people who were of Indian origin. They once held Indian passport. So they were once the citizens of India. Now they are the citizens of other countries, doesn't matter. But if they want to come to India, they can come to India without any visa for 15 years. If their stay in India is for less than 6 months, they don't have to report to the police. But if their stay is for more than 6 months, they have to report to the police. Another person who is a person of Indian origin is, if he or either his parents or grandparents or great-grandparents were born in and were permanently resident of India. In a sense, I am the citizen of US right now. My parents were also the citizens of US. But my great grandfather or great grandmother were the citizens of India. Now I become whom? I become the person of Indian origin. The government is telling me, if you want, if you wish, apply for this card known as PIO card. And using this PIO card, you can come to India without any visa for 15 years. If your stay is for less than 6 months, you don't have to report to the police. If your stay is for more than 6 months, you have to report to the police. That means we want to ensure that you seamlessly can enter India and leave India. For that, there was a scheme launched by MHA known as PIO, Person of Indian Origin Scheme, which was launched in the year 2002. 3 years later, Citizenship Amendment Act was passed, which means the Citizenship Act of 1955 was amended again. And it was amended in the year 2005. What was the purpose? The purpose was any foreign national. We can call that foreign national as overseas citizen of India. So basically an improved scheme was launched known as Overseas Citizen of India. But this time it was not launched by MHA. This time a law was passed. This time Citizenship Amendment Act was amended to incorporate, to start the scheme known as Overseas Citizen of India. And what is the benefit? If you are a foreign national and you were eligible to become the citizen of India on 26 January 1950, you were eligible, but you did not apply for Indian citizenship, but you were eligible to become the Indian citizen. Who was eligible to become the Indian citizen on 26 January 1950? If you were residing in India continuously for the 5 years, but now you decided not to continue in India, you wanted to travel to abroad and you became the citizen of another country. But you were eligible to become the citizen of India on 26 January 1950. Or you were a citizen of India on or at any time after 26 January 1950. You were the citizen either on 26 January 1950 or after that as well. But right now you are not a citizen of India. You are a foreign national. But you are not from Pakistan or Bangladesh. Because Pakistan and Bangladesh was an undivided India. It was part of the single country. Pakistan, Bangladesh, India, it was part of one country, India. But if you are now, because by that logic, all the Pakistanis and Bangladeshis could have become eligible for OCI card, because they were eligible to become the Indian citizens on 26 January 1950. Because if they wanted, they could have stayed in India. So these citizens are not, these foreigners are not eligible for this. And these foreign nationals, if they apply for OCI card, Overseas Citizen of India card, they can come to India without any visa for life. Not for 15 years only, for life. And whether their stay in India is for 6 months or more than 6 months, doesn't matter. They don't have to report to the police. So an improved version of a scheme targeting the diaspora, targeting those who had Indian connection, was Overseas Citizen of India 2005 scheme. But then some people alleged and said, Overseas Citizen of India, which has much improved benefits, which means you can come to India without any visa for life. Whether your stay in India is for 6 months or more, doesn't matter. You don't have to report to the police. Some demanded that the same protection be given to person of Indian origin as well. Then Mr. Modi came to power. He went to a Madison Square in United States, addressed a massive crowd of those who had Indian connection, members of diaspora, those who were previously Indians, or those whose parents were Indians, or those whose grandparents were Indians, those who had an Indian connection, addressed them and said, Mitro, for you I have a good news. The good news is we are merging the two schemes. PIO scheme will be discarded. If you have the PIO card, you can convert it into an OCI card, Overseas Citizen of India card. And now you can come to India without any visa for life. Whether your stay is for 6 months or less than 6 months or more than 6 months, doesn't matter. You don't have to report to the police. So we are making your entry and exit from India as seamless as possible. And for that, these two schemes are merged. Now, we don't have a PIO scheme. There is only one scheme known as OCI. But when we look at this term, this phrase, overseas citizen of India, it was also misleading. Misleading in the sense, on one hand, we are saying that there is no such thing as dual citizenship. You're only the citizen of India, you're not the citizen of any other country. But on the other hand, we are saying overseas citizen of India, which means we are giving a sense that there is somebody who is also not a resident Indian citizen, but an overseas citizen of India. To resolve this confusion, this scheme was renamed as Overseas Citizen of India Card Holder Scheme. That means you are not an overseas citizen of India, you are an overseas citizen of India card holder, which means you were once eligible to become the Indian citizen, or you once held the Indian passport, or your parents were Indians, or your parents were eligible to become Indians, or your grandparents were Indians, or your grandparents were eligible to become Indians. All of you put together, whether condition is PIO or whether condition is OCI, all of them put together, you are eligible for one card known as Overseas Citizen of India card holder. And once you have this card, you can come to India without any visa for life. You don't have to report to the police because you are basically helping strengthen India by sending remittances, by using your power in your respective countries to persuade your governments to have good relations with India. These are the two schemes, PIO and OCI. Any questions, let me know. There had been a concept of Yas Soli in near 1950 in India. Can a person now living abroad apply for OCI card if she had been born in India in 1950? Yes, you can apply for OCI card. It's precisely the scheme for you. And plus, I told you that we will discuss more conditions related to registration. If, for example, there is a PIO card holder, there was a PIO card holder, or there is an OCI card holder, what you have to do, can you become an Indian citizen now? Yes. How? Through registration. How? All you have to do, come to India, stay in India for 5 years. If you stay in India for 5 years, you are eligible to apply for Indian citizenship through registration. Is NRI having Indian citizenship? My dear, have we discussed NRI yet? We haven't. So when we haven't, I will not answer. Patience, my dear. We'll discuss NRI after this. That's what is mentioned here. An NRI is an Indian citizen. I'll tell you, but be patient. Ask me about OCI and PIO. Any foreigner can apply for OCI card. Any foreigner who meets this condition, who once had an Indian connection, who once held an Indian passport, who once was an Indian citizen, whose parents once were Indians, whose grandparents once were Indians, or at least eligible to become Indians, only they can apply for OCI. Sir, if there is no visa, no reporting at FRRO, then how will government know that any OCI is in India? My dear, immigration check. You get down from the plane, you buy the ticket, you come to India, at least at the time of the immigration, your passport will be stamped. That's how the government will come to know that you are an overseas citizen of India. Why neighbor countries are not allowed for PIO? Because by that logic, if neighboring countries are allowed, all of them would become eligible to apply for OCI. All the Pakistanis and Bangladeshis will become eligible for OCI. Then they will come to India without any visa for life. Masood Azhar can come to India without any visa. Clear? So we'll have to impose restrictions. Okay, so let's take a break. We'll meet again 7:55 a.m. See you on the other side of the break. Shall we continue? Okay. Now, who is an NRI or a non-resident Indian? For example, taxes are imposed on the people of India. You'll have to pay income tax on the entire income that you generate from India. Clear? Now, these NRIs, non-resident, these are Indians. That means, are they Indian citizens? Yes. Can they vote in India? Yes, because they are the citizens of India. Can they contest the elections? Yes, they are the citizens of India. Because the citizens can vote, citizens can contest elections, citizens can apply for government jobs. NRIs are Indians. It's just that they are not resident of Indians. They are not residing in India, but they are Indians. And this is primarily done for tax purposes. Because if you're not residing in India, why would you pay tax in India? You'll have to pay tax in the country where you're working. And for that, Income Tax Act defines who is a resident Indian and who is a non-resident Indian. Resident Indian, non-resident Indian, tax purposes. This will be discussed in economics as well. How these NRIs should be taxed, how they should not be taxed, for example. But from the GS polity point of view, what is it that you have to understand? Listen to me carefully. Whoever is a citizen and is residing in India for more than 182 days in a financial year, that person is a resident. That means, who is a resident of India? Somebody who is residing in India for more than 182 days in a year, which may also include foreigners. For example, foreigners who are residing in India for more than 182 days, they have to pay tax in India. For example, Akshay Kumar pays tax in India. Alia Bhatt pays tax in India. Why? Because although they are foreigners, but they are residing in India for more than 182 days in a financial year. So whatever money they generate from India, whatever income they generate from India, on that income they have to pay tax because they are the residents of India. But whoever is an Indian citizen, but is residing in India for less than 182 days in a financial year, for less than 182 days in a financial year, those individual citizens become NRIs, non-resident Indians, so that their tax liability, so that the jurisdiction where they have to pay the tax, that is not India, that is where they are working. That's what we call NRI, non-resident Indian. These are Indians, but just that they are not residing in India. If they are residing in India for less than 182 days in a financial year, their tax liability is not in India. They have to pay tax in a country where they are working, they are generating income. Those are what we call non-resident Indians. But then changes were made a couple of years ago by the Finance Ministry. What were the changes? Changes were made to the Income Tax Act. What were the changes? The government realized that there are some Indians who deliberately plan their stay in India in such a manner that they reside in India for less than 182 days in a financial year. That means, although they generate income from India, they have their businesses in India, they generate income from India, but they plan their travel in such a manner that they reside in India for less than 182 days in a financial year, which means they don't have to pay tax in India, which means they evade taxes. Then the government said, if there is an individual whose income is 15 lakhs or more generated in India. Such an individual, if he stays in India for less than 120 days, that person is an NRI. If you stay in India for more than 120 days, you become a resident. When you are a resident, you have the liable to pay tax in India. Long story short, who is a person of Indian origin? We've discussed that, but these are not Indians. They are persons of Indian origin, but now they are the foreigners. Overseas citizen of India. They're not the citizens of India. They may have been the citizens of India previously. They may have held Indian passport previously. Their parents may have been Indians. Their grandparents may have been Indians, but they are not Indians. They are foreigners. But then who are the non-resident Indians? These are Indians. But just for tax purposes, we have to decide whether they are resident Indians, because they have to then pay tax in India, or they are non-resident Indians. That means they don't have to pay tax in India. They have to pay tax in a country where they are working. The rules say, Income Tax Act says, whoever is an Indian but is staying in India for more than 182 days, you become the resident of India, which means you have to pay tax in India. But if there is an individual, there is an Indian who stays in India for less than 182 days in a financial year, they don't have to pay tax in India. They have to pay the tax where they are operating from, in a country where they are operating from. But then the government realizes that there are these individuals, wealthy individuals, who generate income from India, who have businesses in India, who have factories in India. They generate income from India, but they plan their travel in such a manner that they reside in India for less than 182 days because they evade taxes then. They don't have to pay tax here. It is for this reason that the government said, now those individuals whose income from India is more than 15 lakhs in a financial year, and if such individuals reside in India for less than 120 days, they become NRIs. They don't have to pay tax in India. But those who generate income of 15 lakhs from India and stay in India for more than 120 days, they become a resident of India and they have to pay tax in India. And there is also a proposal by the Election Commission, supported by the government as well, that these NRIs who are Indians, but they can't come from abroad to India at the time of elections to cast their vote. They should be allowed to vote in that country for Indian elections. But whether they will be allowed to vote, how they will vote, that is something that we will discuss in a chapter known as elections. But we will not discuss it now because that relates to elections. We'll discuss that in elections chapter. But it doesn't matter whether you are a citizen of India by birth or descent or registration or naturalization or by incorporation of the foreign territory. It doesn't matter from which route you have become the citizen of India. You can contest elections, you can vote, you can become the president, the prime minister. For example, Sonia Gandhi. Srimati Sonia Gandhi, although she is a citizen of India through registration, but nevertheless, she is the citizen of India. Can she become the Prime Minister of India? Yes. Is she a member of the parliament? Yes. Can she vote? Yes. That means it doesn't matter whether you are a citizen of India by birth or naturalization, you are eligible to become the citizen of India. You are eligible to vote to become the president or the prime minister. Unlike United States. In United States of America, the president of the United States should be the citizen by birth. A naturalized US citizen cannot become the president of the United States. In order to become the president of the United States of America, this person should be the citizen of US by birth. But in India, whether you are citizen by birth or registration or naturalization or descent or by incorporation of the foreign territory, you can become the president, prime minister, minister, you can contest election, you can vote as well. Present immigrants are considered NRIs. If they stay outside India for more than 182 days, they become the NRIs. Okay, done. Now, who is a domicile? You may be the citizen of India, but you are a domicile of Maharashtra. You may be the citizen of India, but you may be a domicile of Karnataka. You may be the citizen of India, but you may be the domicile of Jammu and Kashmir. Who is a domicile? This term domicile is not defined in the Constitution. So Constitution does not talk about this term domicile. But who is a domicile? Ordinarily, it means a permanent home or a place where the person resides, but with the intention of remaining there for an indefinite period. And this is where we come across two types of domicile: domicile of origin, domicile of choice. What does that mean? For example, you were born in Delhi. So Delhi becomes your place of birth. But you have enrolled in a school in Delhi. You have done your graduation from Delhi as well. You are now working in Delhi as well. You have your family in Delhi as well. What does that mean? That means Delhi is your place of birth, but Delhi is also a place where you have the intention of residing for an indefinite period. That means Delhi becomes your domicile. Clear? But then Delhi, which is the place of birth where you were born, but then you migrated from Delhi, you came to Karnataka. And in Karnataka, you did your schooling. In Karnataka, you graduated as well. In Karnataka, you have applied for job as well. Whether in private sector or government sector, doesn't matter. That means you are now residing in Karnataka for a long period of time, for an indefinite period of time. That means it is your intention, although you were born in Delhi, but you are now residing in Karnataka, and it is your intention to reside in Karnataka for an indefinite period. Karnataka becomes your domicile. Then what is the benefit? For domiciles, there can be a reservation in government jobs. For domiciles, there can be reservation in educational institutions. That means Karnataka can reserve some of its government jobs for those who are the domiciles of Karnataka. Karnataka can reserve educational institutions seats for those who are the domiciles of Karnataka. So what is a domicile? Domicile is not same as place of birth. Domicile is not same as resident, which means you may be from Manipur, but you are residing in Karnataka. That doesn't mean you become domicile of Karnataka. That doesn't mean in Karnataka seats will be reserved for you because you are still the domicile of Manipur. But if you are from Manipur, but you have now migrated to Karnataka and you have resided in Karnataka for, let's say, 15 years, that means for 15 years, Karnataka is your residence, which means if you have stayed in Karnataka for 15 years, it is your intention to reside in Karnataka for an indefinite period. Karnataka becomes your domicile. And for you, seats can be reserved in government jobs, seats can be reserved in educational institutions. That is what we call domicile. So what is domicile? Domicile is, number one, not defined in the Constitution. But domicile is not same as place of birth. Domicile is not same as residence. Domicile is residence plus the intention to reside for an indefinite period. And this is where we come across two types of domicile. Domicile of origin. What's your origin? You are from Delhi. That is your origin. That's your place of birth. And if you stay in Delhi for an indefinite period, you become the domicile of Delhi as well. But if you start migrating to Maharashtra, for example, this is what we call animus menendi, change of mind, change of thought, where your status of mind changes. And now you come to Maharashtra. You reside in Maharashtra for an indefinite period, which may be 15 years. And ultimately, you become the domicile of Maharashtra. And in Maharashtra, seats can be reserved for you. In Maharashtra, seats can be reserved in educational institutions, in government jobs. That is what we call domicile. Clear? Who defines the indefinite period? The government decides this. For example, in Jammu and Kashmir, the last state or last union territory where the domicile rules were changed, the central government says whoever has resided in Jammu and Kashmir for 15 years becomes the domicile of Jammu and Kashmir. If there is a member of All India Service, for example, IAS, IPS, Indian Forest Service, if you have worked in Jammu and Kashmir, you become the domicile of Jammu and Kashmir. Your kids also become the domicile of Jammu and Kashmir. That means those who are the domiciles of Jammu and Kashmir, they get reservation in jobs, they get reservation in educational institutions. So domicile rules may vary from state to state, but you can't have two domicile certificates. For example, you cleverly decide that I will be the domicile, I will get the domicile certificate from Karnataka. I will also get the domicile certificate of Telangana. So that when the admission is to be taken in engineering college or a medical college, I can see and choose where I get the best college. Because I have the domicile certificates of both Karnataka as well as Telangana, for example. So for domicile seats are reserved, I will see where I will get a better college and I will apply in that college. I will enroll in that college. Having two domicile certificates is a crime. This is what happened to a student from Rajasthan who had a domicile of Rajasthan because he was born and brought up in Rajasthan. But then he took up the domicile of Karnataka as well. Why? Because he thought that I will reside in Karnataka for a long time. His family was in Karnataka, so he was a domicile of Karnataka as well. He applied for a domicile in Karnataka without giving up the domicile of Rajasthan. And then his intention was to get a good engineering college in Karnataka. Somebody complained. It was realized that he possesses two domicile certificates of Rajasthan as well as Karnataka. He was barred from appearing, enrolling in educational institutions for 4 years. So having two domicile certificates is a crime. Sir, I was born in Haryana but live in Delhi for 12 to 14 years and have the intention to stay in Delhi. Can I have two domiciles? No, ma'am. No. You can have only one domicile. Either choose Haryana or choose Delhi. Who issues this certificate? The district authorities. Okay. Now let's look at Citizenship Amendment Act 2019. So what is the Citizenship Amendment Act? That means basically in the year 2019, the Citizenship Act, which was passed in the year 1955, it was amended again in 2019. So what is the Citizenship Amendment Act? Parliament in 2019 amended the Citizenship Act of 1955, and that is what we call CAA 2019 or Citizenship Amendment Act 2019. And to understand that, we need to understand, again, very briefly, who can become the citizen of India. If you are born on the soil of India, one of the parent is an Indian, other is not an illegal migrant. Can you become the citizen of India? Yes. That means under no circumstances can illegal migrants become the citizens of India. Prior to 1987, no matter who you are, if you are born on the soil of India, you become the citizen of India, regardless of the citizenship of your parents. But after 2003, the child born on the soil of India can become an Indian only if one of the parent is an Indian and the other is not an illegal migrant. So illegal migrants are not eligible for citizenship. Their children are not eligible for citizenship. Now the government said something else. Government said that there are three countries, Pakistan, Afghanistan and Bangladesh. These are the three countries in our neighborhood. These are the three predominantly Islamic countries where Islam is the state religion: Pakistan, Afghanistan, Bangladesh. And in these three countries, they have religious minorities. Who will be the religious minorities in these three Islamic countries? Non-Muslims, which means Hindus, Christians, Sikhs, Buddhists, Jains, Parsis. The government said in its election manifesto, the BJP said in its election manifesto that there are 6 religious minorities in 3 Islamic countries where these minorities are persecuted. Persecuted in the sense they are forced to convert to Islam. Because of their religion, they are discriminated against. Their daughters are kidnapped. Their daughters are raped. They are denied dignity. They are denied liberty. And these individuals belonging to 6 religious minorities from 3 Islamic countries, Pakistan, Afghanistan, Bangladesh, when they were being persecuted in these countries, what they did, they fled these countries and they came to India. Because they wanted to save their lives, they wanted to save their dignity, preserve their dignity. They fled these countries because they were facing persecution. They were persecuted in these countries. They fled these countries, they came to India. But they do not come to India on a valid visa, which means they are illegal migrants. That means these 6 religious minorities from 3 Islamic countries who were facing persecution because of their religion, they fled these countries, they came to India, and now in India they are illegal migrants. But illegal migrants are not eligible for citizenship. We will give them citizenship. And that is the whole purpose of Citizenship Amendment Act 2019. All the 6 religious minorities from Pakistan, Afghanistan, Bangladesh, belonging to Hindus, Christians, Sikhs, Buddhists, Jains and Parsis, if they have come to India on or before 31st December 2014, if these 6 religious minorities from Pakistan, Afghanistan, Bangladesh, if they have fled these countries and have come to India, when? On 31st December 2014 or before 31st December 2014, they will not be deemed as illegal migrants. That means although they are illegal migrants, but they will not be deemed as illegal migrants. When they are not deemed as illegal migrants, that means they are eligible for citizenship. But through which route they are eligible for citizenship? Naturalization. But for naturalization, you have to meet certain conditions. That means you should have resided in India for 11 years out of the previous 14 years. Now the Citizenship Amendment Act said this period of naturalization, this requirement that you should have resided in India for 11 of the previous 14 years, this requirement has been reduced to 5 years. What does that mean? I told you when we discussed union and its territory. What did we tell? That a law passed by the parliament under Article 2 and 3, it will have to make changes to Schedule 1 and Schedule 4 of the Constitution, right? But these changes to Schedule 1 and Schedule 4 are incidental, consequential matters, and as such shall not be deemed as amendment to the Constitution. That means although the parliament, when it makes a law under Article 2 and 3, it will amend Schedule 1, it will amend Schedule 4, but we will not call it amendment. These changes shall not be deemed as amendment. Although they are amendment, but we will not deem that as amendment. That means we don't need Article 368. By simple majority, we can change Schedule 1 and Schedule 4. In the similar fashion, if you are from Pakistan, Afghanistan and Bangladesh, but you belong to 6 religious minorities. And if you have come to India on 31st December 2014 or before 31st December 2014, although you are illegal migrant, but we will not treat you as illegal migrant. So you are not deemed as illegal migrant. When you are not deemed as illegal migrant, which means you are eligible for citizenship. Because are illegal migrants eligible for citizenship? No. Can a German illegal migrant, Nepalese illegal migrant, Sri Lanka's illegal migrant, Bahrain's illegal migrant, US's illegal migrant, can they apply for Indian citizenship? No, because illegal migrants are not eligible for citizenship. But what about from Pakistan, Afghanistan, Bangladesh, belonging to 6 religious minorities? If they have come to India, we will not treat them as illegal migrants. They shall not be deemed as illegal migrants. That means they are then legal migrants. When they are legal migrants, they can apply for citizenship. But through which route? Not through birth, not through descent, not through registration, because they may not also be married to an Indian, but through naturalization. And in naturalization, they have to meet certain conditions. Conditions such as you should have stayed in India for 11 years. The government said, we will reduce this period of naturalization from 11 years to 5 years, and they will be given citizenship. That's the whole point of Citizenship Amendment Act 2019. And for that, the government initially started off with some changes. What were the changes? 2 notifications were issued in 2016 that all these illegal migrants shall be exempted from 2 acts. Foreigners Act of 1946, Passport Entry into India Act 1920. According to these 2 laws, you cannot enter India without a passport of your country. You can't do that. You cannot enter India without the visa issued by the government of India or by the Indian embassy. You can't do that. But the government realized that there are these religious minorities from Pakistan, Afghanistan, Bangladesh. They belong to 6 religious minorities. They have fled these countries because they were facing persecution. They were being persecuted, attacked, ridiculed because of their religion. How will they enter India with a visa? If they are fleeing their country, you flee your country, you fled away from your country without even taking your passport. So you have come to India without a visa, without a passport. The government said, issued a notification that if you are from Pakistan, Afghanistan, Bangladesh, if you belong to 6 religious minorities, you are exempted from having a passport, you are exempted from having a visa. Don't worry about visa, don't worry about passport, come to us. And if you have come to us on or before 31st December 2014, you are eligible for citizenship because we will not deem you as illegal migrants. Illegal migrants even today are not eligible for citizenship, but these are not deemed as illegal migrants. Although you are, but we will not treat you as illegal migrants. That means you are eligible for citizenship. And no matter when you have come to India, if you have come to India in 1955, from that date, you will become the citizen of India. If you have come to India in 2010, from 2010, you are the citizen of India. That means it is not that in 2019 the law is passed and you become the citizen of India from 2019. No, you become the citizen of the country from the date you have entered India. Why? Look at this carefully. If I have entered India in 1955 illegally, then I got married, I have kids as well. Or let's say I entered India after 2003. After 2003, I have entered India illegally. That means I'm an illegal migrant, and the children born to illegal migrants cannot become the citizens. And if I become the citizen of India from 2019, which means those kids will not become the citizens of India because they have not come from Pakistan, Afghanistan, Bangladesh. That is why the law said you will become the citizen of India from the date you have entered India. Whether it is 55, 2010, 2019, 2010, 2014, No matter when you have entered India, from that date, you will be deemed as the citizens of India. Number one. Number two, normally what happens when the government realizes that there are illegal migrants in India, those illegal migrants are arrested. Those illegal migrants, case is filed against them, and this case is filed in foreigners' tribunals. What is a foreigners' tribunal? As of now, I can see there is a lot of questions. Do one thing. Don't ask anything. Just keep quiet. Listen to me. Make notes of whatever I'm discussing. Once this topic is over, I will promise all your doubts will automatically disappear. Why 31st December 2014 is the date mentioned? Why only these communities? How can you prove religious persecution? All this we will discuss one by one. Just listen to me. Don't ask me any questions. When I will tell you that this chapter citizenship is over, after that, whatever questions, whatever doubts are left, shoot, and I will resolve these doubts. As of now, just listen to me patiently. Don't panic. If there are foreigners in India or illegal migrants in India, what the government does, arrests them, cases filed against them in foreigners' tribunals, basically courts, which primarily get to decide whether you are Indians or foreigners. And when the case is filed in these foreigners' tribunals, they have to prove that they have come to India legally. They have to prove that they are citizens of India, for example. If you cannot prove that you have come to India on a valid visa or you are a citizen of India, then you are deported back to your country. Which means if you have come from Bangladesh, you will be deported back to Bangladesh. If you have come from Sri Lanka, you will be deported back to Sri Lanka. Maybe some of these individuals from Pakistan, Afghanistan, Bangladesh, maybe belonging to 6 religious minorities, maybe against some of these individuals, there is already a case pending before the foreigners' tribunals, where they have to prove that they are the citizens of India, where they have to prove that they are not the illegal migrants. That means these foreigners' tribunals will hear this matter, and if they decide that yes, you are an illegal migrant, you will be deported back to Pakistan, Afghanistan, Bangladesh. But there, their life is in danger, because they fled these countries because they saw danger. They were being persecuted because of their religion. Citizenship Amendment Act said if there is any proceeding against them in any court in this country, all these cases will be closed. Long story short, what is Citizenship Amendment Act of 2019? This was the promise of the BJP in its election manifesto, that illegal migrants from Pakistan, Afghanistan, Bangladesh, belonging to 6 religious minorities, we will give them citizenship. But for that, law is to be passed, which means Citizenship Act is to be amended. This was amended in 2019. What does this law say? If you are from Pakistan, Afghanistan, Bangladesh, and you belong to 6 religious minorities of these countries, which means you are Hindus, Christians, Sikhs, Buddhists, Jains, Parsis, and if you have come to India on 31st December 2014 or before 31st December 2014, you are not illegal migrants. We will not call you as illegal migrants. When you are not illegal migrants, which means you are eligible for citizenship, because legal migrants are eligible for citizenship. Illegal migrants are not. We will not call you as illegal migrants. That means you can apply for citizenship. Through which route? Naturalization. But for naturalization, you should have stayed in India for 14 years. Out of the 14 years, you should have stayed in India for 11 years. Now this period, 11 years, is slashed to 5 years. If you have come to India on or before 31st December 2014, the law was passed in 2019. Period of naturalization was 11 years. That is reduced to 5 years. What is the time difference between 2014 to 2005? 5 years. That is why this period is slashed from 11 years to 5 years. If you have come to India on or before 31st December 2014, all you have to do, stay in India for 5 years. And once you stay in India for 5 years, you are eligible for citizenship. But from what date? Adnan Sami became the citizen from the date he became the citizen. He was given the certificate. But you have come from Pakistan, Afghanistan, Bangladesh. You have come on or before 31st December 2014. No matter when you have come, whether in 50, 60, 70, 80, 90, 2000, 2010, 2014, from the date you have entered India, from that date, you will be deemed as the citizens of India. And maybe against some of you, there are legal proceedings going on in foreigners' tribunals. Whether there is a case of illegal migration against you, all such cases will be closed because you will be deemed as the legal migrants. You're not illegal migrants. But then some exceptions were added. Exceptions in the sense, this provision of Citizenship Act will not apply to the tribal areas which are under 6th schedule of the Constitution. Under 6th schedule of the Constitution, there are 4 states: Assam, Meghalaya, Mizoram, Tripura. Not the entire Assam, not the entire Mizoram, Meghalaya and Tripura are tribal states. There are 3 districts in Assam which come under 6th schedule of the Constitution. There are 3 districts in Meghalaya, 3 districts in Mizoram, 1 district in Tripura, which is a tribal district. In these tribal districts, these migrants will not be settled. Because who are these tribals? Tribals are people with distinct language, script, culture. They have their own culture. And to preserve culture of these tribals, these migrants from Pakistan, Afghanistan, Bangladesh, once they are given citizenship, they will be made to settle in any part of the territory of India, from Kashmir to Kanyakumari, from east to west, in any part, any territory, any state in India, they will be made to settle, except in the tribal areas of Assam, Meghalaya, Mizoram and Tripura. These 10 districts of these states, these illegal migrants will not be made to settle. Then there are areas which are under inner line permit. What is this inner line permit? This was introduced by the British under a law known as Bengal Eastern Frontier Regulation. The year was 1873. Inner line permit. What was this inner line permit? Basically, some areas where you cannot enter without the permission of the state government. For example, Nagaland. For example, Mizoram. For example, Arunachal Pradesh. If you want to enter Arunachal Pradesh, you're not from Arunachal Pradesh, you are from Delhi or Karnataka or Maharashtra. You are an Indian, but you want to enter Arunachal, or you want to enter Mizoram, or you want to enter Nagaland, you cannot enter these states without the permit issued by the state government. State government has to allow you to enter these areas, without which you cannot enter. This is to preserve the culture of these states. The Law Citizenship Amendment Act says this Citizenship Amendment Act will not also apply to these inner line permit areas. That means these illegal migrants who are now or who can become the citizens of India, they will be made to settle in any part of this territory, except the tribal areas which are under 6th schedule of the Constitution, except those areas which are under inner line permit, for example, Arunachal, for example, entire Mizoram, for example, Nagaland, and to which Manipur will also be added. So which means these illegal migrants from Pakistan, Afghanistan, Bangladesh, belonging to the 6 religious minorities, will not be made to settle in the tribal areas under 6th schedule, in those areas which are under inner line permit, which is Mizoram, which is Nagaland, which is Arunachal Pradesh, which is now Manipur as well. So Manipur also we will see inner line permit. That means these migrants will not be made to settle there. That means these migrants who will now be given citizenship of India, they can settle anywhere within the territory of India except these areas. To protect tribal culture, from this, as I said, this act further reduces the period of naturalization for such groups. That means not for all. If there is an individual from Germany or Switzerland or from US and you want to become citizen of India through naturalization, you have to stay in India for 11 of the previous 14 years. But only for those who come from Pakistan, Afghanistan, Bangladesh, that too before or on 31st December 2014. For you, the period is reduced to 5 years. And at the same time, this act also talks about the grounds for the cancellation of OCI. What is OCI? Overseas Citizen of India Card Holder Scheme. You're holding a card, which means if you are a foreign national, you were once the citizen of India, or your parents were once the citizens of India, or eligible to become the citizens of India, you are given an OCI card, which means you can come to India without any visa for life. Whether your stay in India is for 6 months or more than 6 months, doesn't matter. You don't have to report to the police. But OCI card could have been cancelled on 5 grounds. It's not that once OCI card is given, we cannot cancel it. The government could have cancelled in not 5 grounds. Now, 6th ground has been added by Citizenship Amendment Act 2019. What were the previous 5 grounds on the basis of which your OCI card could be cancelled? Number 1, if it was done through fraud. For example, you are from Pakistan, but you applied for OCI card, you got the OCI card, but you faked it and said you are from Russia, but you were ideally from Pakistan. That means you got this OCI card through fraud. Once the government comes to know about this, your OCI card is cancelled. Second, you're an OCI card holder, you come to India, but here you are organizing protests, demonstrations, you're abusing the constitution, you're violating the constitution, you're being disloyal to the constitution, your OCI card will be cancelled. You are an OCI card holder, but you came to India. Right now, India and China is at war. Now you are supporting China. You are having business with China. You are having deals with China. That means you are engaging with an enemy country during war. Your OCI card will be cancelled. You are an OCI card holder, but you come to India, you are organizing protests. You are entering into the tribal areas. You are instigating tribals to go against the government of India. You are talking to the Naxalites. You are talking to the Maoists. You are speaking with the separatists. You are dealing with the terrorists. It is necessary in the interest of sovereignty of India or public order to cancel your OCI card. Your OCI card could be cancelled. Your OCI card was given today, but within 5 years, when you were given this OCI card, you had committed a crime for which you have been sentenced to 2 years or more in jail. Your OCI card will be cancelled. That means OCI card once given, it could be cancelled or it could have been cancelled on 5 grounds. Now, Citizenship Amendment Act of 2019, apart from saying that people from Pakistan, Afghanistan, Bangladesh, 6 religious minorities from these 3 Islamic countries, apart from telling that they will get citizenship through naturalization, this CAA 2019 also included a 6th ground on the basis of which your OCI card could be cancelled. Now, the law says if the OCI has violated any law that is in force in this country, any law that is in force in this country, if you violate any law, your OCI registration will be cancelled. Any law can be violating Motor Vehicles Act, violating Aadhaar, violating any law passed by the Parliament, Child Labour Act. Any law, if you have violated, which is in force in this country, your OCI card could be cancelled. This was the 6th ground mentioned in the Citizenship Amendment Act. These are the provisions under Citizenship Amendment Act. Now we have to look at the arguments in favor of CAA. We have to praise CAA because the question can be justify CAA. We'll have to look at arguments against CAA as well. We'll have to criticize CAA as well. That's something that we will do now. Any questions as of now? If exception for Assam, then why migrants issue in Assam? Why NRC is there? We'll discuss that today. What is the sense behind adding 6th rule in OCI card cancellation through CAA? Because, my dear, Overseas Citizen of India scheme was launched under the Citizenship Act 1955. If you have, this act also talked about 5 grounds on the basis of which your OCI card could be cancelled. So if you have to add a 6th ground, for that you have to amend this act again. And for that, CAA 2019 added the 6th ground. Clear? Had any OCI card been cancelled? Yes, for example, Atish Tasir, journalist. He writes for the Time magazine. He's the son of noted journalist Tavleen Singh. Tavleen Singh writes every Sunday in the Indian Express, one very popular column. He's a journalist. And but the father was a Pakistani. For example, Salman Tasir was the name of the father of Atish Tasir. But Salman Tasir and Tavleen Singh, they got married, then they got divorced as well. Salman Tasir was the governor of Punjab, the Pakistani side of Punjab. But then he was assassinated by his bodyguard. Why was he assassinated? That's not our concern. But he was assassinated. The point is, Atish Tasir, son of Tavleen Singh and Salman Tasir. But Salman Tasir and Tavleen Singh, they are not together now. And in fact, Atish Tasir never met the father till he was 21 years of age. That means he was brought up by his mother. He was brought up by his grandmother. And since he had an Indian connection, he is now the British citizen, he applied for OCI card. And both mother and son, they were the biggest cheerleaders of Mr. Modi. Cheerleaders in the sense they were supporting Mr. Modi to become the Prime Minister in 2014. They wrote beautiful articles praising Mr. Modi. But suddenly they became critics of Mr. Modi. And just before the 2019 elections, Lok Sabha elections, the Time magazine, in its cover story, the front story, called Mr. Modi India's divider-in-chief. And this article was written by Atish Tasir. This column was written by Atish Tasir. And once the government came back to power, Atish Tasir's OCI card was cancelled. Why? Because it was argued that he had applied for OCI card, acquired OCI card through fraud. Fraud in the sense, he did not reveal that his father is a Pakistani. So on that grounds, his OCI card was cancelled. Sir, in the last slide, it is CAA 2015. Where is CAA 2015? CAA 2015 can be when OCI card and PIO scheme was merged. That was done through Citizenship Amendment Act, which was passed in 2015. Because that's what I told you right at the start. The Citizenship Act has been amended multiple times. In 57, 85, 86, 92, 2003, 2005, 2015, and the last one was in 2019. What is the difference between passport and visa? Your question has been answered previously. So why are you asking the question again? The subject matter expert has replied to you. Passport means you are an Indian. This passport becomes the document on the basis of which you can travel outside India. But travel outside India to which country? For example, to Germany. Germany should allow you to enter Germany. For that, it will issue a travel document known as visa. Without that visa, you cannot enter Germany. So to come out of India, you need a passport. But to which country you want to come, you want to go, that country should allow you by issuing you a visa, a travel document. I have an intention to live in Karnataka, but I haven't resided in Karnataka yet. Can I take the domicile of Karnataka? Yes, come to Karnataka, stay here for 15 years, then you can apply for domicile. Can someone reapply for OCI card? Yes. Okay. Now let's look at the arguments in favor of Citizenship Amendment Act. When this law was passed, there were a series of protests in different parts of the country, and these protests were particularly led by the Muslims, particularly the Muslim women, for example, in Delhi at Shaheen Bagh. It was argued that CAA is anti-Muslim because it excludes Muslims. Why? Because if you have come from Pakistan, Afghanistan, Bangladesh, but you belong to 6 religious minorities and Muslims are excluded, that means Muslims from these countries cannot apply for Indian citizenship. So it was viewed as some sort of anti-Muslim legislation. That is why there were protests in different parts of the country. These protests only ended when COVID-19 pandemic started in India. Otherwise, these protests continued for a long time, particularly in Delhi at Shaheen Bagh, led by Muslim women. But this is a law to confer citizenship, not deprive citizenship. For example, does this law at any point in time say that those Indian citizens who are Muslims, they will no longer become the Indian citizens? It doesn't talk about this. So Citizenship Amendment Act is a law which confers citizenship on those who have fled these countries because of their religious persecution. This is not a law to deprive Indians of their citizenship. So Indians in no way are affected. It is only a law which is to provide citizenship to those who have come from abroad. So why should Indian Muslims have a problem with this law? This is not a law to deprive Indian Muslims of their citizenship. That's argument number 1. Argument number 2, the question was raised by the protesters, by politicians as well, by opposition leaders, that Article 14 has been violated. Article 14, which is a fundamental right, which talks about equality before law, which means law should treat everybody equally. There should be equality before law. And if there is Citizenship Amendment Act, it should not discriminate. The law should treat everybody equally. And this Article 14 applies to citizens as well as aliens. So if there are aliens from Pakistan, Afghanistan, Bangladesh, this law should treat all of them equally because Article 14 applies to aliens as well. But this law is not treating everybody equally. The law is saying only Hindus, Christians, Sikhs, Buddhists, Jains, Parsis are eligible for citizenship, not Muslims. So since you discriminate against Muslims, you are violating equality before law, which is violation of Article 14. That was the position of the protesters. But Article 14 does not only talk about equality before law. Article 14 talks about equal protection of the law. What is equal protection of the law? For that, Article 14 says there is something called intelligible differentia. What is that? Which distinguishes persons or things that are grouped together from others that are left out. And one which has a rational relation to the object to be achieved by the statute in question, by the law in question. What does that mean? Let's elaborate. For example, Article 14 or equal protection of the law, it basically means like should be treated alike. Alike in the sense, if you have committed murder, no matter what your religion is, what your caste is, what your language is, what your gender is, you will all be booked under Section 302 of Indian Penal Code. That means no discrimination whatsoever. You are a murderer. If Hindu murderer and a Muslim murderer are treated separately, that would be violation of Article 14. Because they are similar. Both are murderers. Regardless of your religion, you are murderers. We will treat you equally. But can murder be equated with, let's say, cheating in the examination? No. All those who cheat in the examination, they are to be treated separately. All those who commit murder, they are to be treated separately. For murder, we can have death sentence. For cheating, we cannot have death sentence. That is why we say intelligible differentia. If Article 14 talks about equality before law, which means law cannot deny equality. Law cannot discriminate. But that's only half of Article 14. The other half is equal protection of the law. In equal protection of the law, there has to be intelligible differentia. That means intelligently we'll have to differentiate. One group should be differentiated from the other group. And if this differentiation is done reasonably, if this differentiation is done logically, then it is not violation of equality. In a sense, Dalits, members of SC community, ST community, OBC community, they have reservation in government jobs, educational institutions. But general category students, they don't have reservation. Clear? Does that mean we are violating equality? No. Why? Because these people belonging to SC, ST, OBC community, they were discriminated throughout history. General category students were not discriminated. The general category caste groups were not discriminated. So if we are classifying them differently, intelligently, we are differentiating between two groups. It is not violation of equality. It is basically justice. We are giving justice to those who have been discriminated against. That is equal protection of the law. To make it even clear, equal protection of the law means we can have groups and we can separate the two. For example, groups is Hindus, Christians, Sikhs, Buddhists, Jains, Parsis. Other group is Muslims. By treating Muslims separately and Hindus, Christians, Buddhists, Jains, Parsis separately, is that violation of equality? No. Why? Because we are separating them. Why separating? Because these groups, they have been persecuted. And who is the persecutor? Muslims. Why? Because in Pakistan, Afghanistan, Bangladesh, which is the majority religion? Islam, Muslims. And if these religious minorities are discriminated against, who discriminates against them? Muslims. Which basically means if CAA would have treated both these groups together, that would have been violation of equality. That would have been violation of equal protection of the law. Because equal protection of the law means like should be treated alike. All those who are religious minorities, they are grouped together. All those who are from majority community in Pakistan, Afghanistan, Bangladesh, they are grouped separately. Article 14 would have been violated if the law would have said only Hindus will be given citizenship. Not Christians, nor Buddhists, nor Jains, nor Parsis, not Jains. If law would have said only Hindus, then it would have been violation of equality. Why? Because not only Hindus are persecuted, other religious minorities are also persecuted. That is why Article 14 is not violated. So what are we discussing? We're discussing arguments in favor of Citizenship Amendment Act. Argument number 1. This can be a question in your mains examination. Justify the enactment of Citizenship Amendment Act 2019. Let's justify. Number 1, it is not a law to deprive Indians of citizenship. Indian citizens are not affected by this law because this law has a target group, Pakistan, Afghanistan, Bangladesh, and 6 religious minorities of these 3 countries, Indian citizens are not affected. So this is not a law which says Indians will be deprived of citizenship. It's not like we have fixed seats, 1,000 seats which we have to fill. And if we give 1,000 citizenship to these 3 countries, we have to remove 1,000 Indians from that list. There is no such thing. That is why one argument in favor of this law is this is a law to confer citizenship, not deny citizenship or deprive citizenship. Second, protesters said Article 14 is violated. What is Article 14? Equality before law. What is equality before law? Law should treat everybody equally. But CAA 2019 is treating Muslims separately. This is violation of Article 14. Article 14 is a fundamental right. And this Article 14 is applicable for citizens as well as foreigners. That means citizens as well as aliens. But that's only half of the story. Article 14 not only talks about equality before law, it talks about equal protection of the laws. And in equal protection of the laws, there can be intelligible differentia, which distinguishes persons or things, and these persons or things are grouped together from another group. So all the minorities are in one group. The majority community is in another group. And we will give protection to the minority, to one group, not to the other. And this is what we call there is rational relation to the object. What is it that you want to achieve through this law? What do you want to achieve? You want to give citizenship to those who have been persecuted? All those who have been persecuted are in one group, and the persecutor is in another group, and we are giving protection to only the persecuted. Article 14 is upheld. Article 14 is not violated. That's argument number 2 in favor of Citizenship Amendment Act. Argument number 3. Indian Muslims are in no way affected by this amendment. They are and will continue to enjoy the benefits of the legitimate citizenship. This act deals with refugees who are foreign citizens. This act does not talk about Indian Muslims. This act talks about foreigners who are refugees in India, and we have to give them protection. And this is the guiding philosophy behind India's independence, that we need to ensure dignity to all the people. We have given refuge to the Nepali citizens. We have given refuge to the Tibetan migrants. We have given refuge to Sri Lankan Tamils. We have given refuge to Parsis, which have come thousands of years ago. And if in our neighborhood, there are people who are being victimized and persecuted because of their religious identity, because of their religious ideology, India should have an open heart to welcome such individuals, to welcome such groups, and we will give them citizenship. So that goes way into the philosophy of India. But then there were other protesters who said, what about Tibetan refugees? Why don't you give them citizenship through CAA? What about Sri Lankan Tamils? Why don't you give them citizenship? Now, this is the policy of the government. And policy making is the job of the executive. Job of the executive, which means the government of the day. Right now, the government is focused on religious persecution. But Tibetans, they are not persecuted by China because of their religion. They are persecuted by China because of their ethnicity. Sri Lankan Tamils, they are not discriminated and persecuted in Sri Lanka because of their religion. They are persecuted because of their race, because of their language, because of their Tamil language. So right now, it is the policy of the government that we will first focus on religious persecution. Because in Pakistan, Afghanistan, Bangladesh, these minorities, they are not persecuted because of their ethnicity, because of their race, because of their language, because of the color of their skin, because of any other food that they eat, because they are persecuted because of their religion. And we will first focus on religious persecution. Tomorrow we may focus on ethnic persecution or racial persecution or any other kind of political persecution. We'll focus on that sometime later. But right now it's the policy of the government to focus on religious persecution, focusing on religious minorities. And policy making is the job of the executive. You may disagree with the policy, but ultimately policy making is the job of the executive. Similarly, there were some who said Article 15 is violated. What is Article 15? Article 15 talks about no discrimination. The state shall not discriminate only on the grounds of religion, race, caste, sex, place of birth. So explicitly Constitution has a non-discriminatory provision. That means you cannot discriminate on the grounds of religion. Since under CAA, religion is the basis of discrimination. You are specifically singling out religion, that these religious communities will get citizenship. This religious community will not get citizenship. So you are discriminating on the grounds of religion, which is violation of Article 15. As such, CAA is unconstitutional. Okay, even if we agree that yes, it discriminates on the grounds of religion, but discriminates whom? Citizens or foreigners? Foreigners. Article 15 is exclusively available to citizens. That means Constitution says the state shall not discriminate against its citizens only on the grounds of religion. Indian citizens are not discriminated on the grounds of religion by CAA. It is the aliens, it is the foreigners, it is those who are not the citizens of India. They are discriminated on the grounds of religion. So Article 15 is not violated. Then there are others who say Article 21 is violated. What is Article 21? Right to life and personal liberty. Which is also available to foreigners. And these individuals, they specifically point out to a principle known as principle of non-refoulement, which is mentioned under United Nations Convention on the Rights of Refugees. What is principle of non-refoulement? For example, these are individuals they are from a country called Pakistan. Clear? But they have fled Pakistan and they have come to India. And they have come to India out of fear. And if they have come to India out of fear, it is obligation on India under the principle of non-refoulement that you cannot send these individuals back to the country where their life is in danger. Principle of non-refoulement, which is mentioned under United Nations Convention on the Rights of the Refugees, under which, if, for example, there are Hindus, Christians, Buddhists, Jains, Parsis, Sikhs, if they have migrated to India because they fear for their life in Pakistan, Afghanistan, Bangladesh, it is the responsibility on India under United Nations Convention on the Status of Refugees that you cannot send these people back to these countries where their life is in danger. But the point is, India is not a signatory to this convention. India has not ratified this convention. India is not part of United Nations Convention on the Status of Refugee. Yet, despite that, we are agreeing with the spirit of this convention. We are saying that we will not send these Hindus, Christians, Sikhs, Buddhists, Jains, Parsis back and deport them to Pakistan, Afghanistan, Bangladesh, because their life will be in danger in these three countries. So despite the fact that we are not part of this United Nations Convention on the Status of Refugee, even then we accept the spirit of this law and we uphold their right to life. So Article 21 is not violated. Article 21 is upheld by Citizenship Amendment Act. Then there were others, protesters, who said that tribal interest is getting violated because you will settle these migrants in tribal areas. Their protection is also taken care of because Citizenship Amendment Act will not apply to the tribal areas, will not apply to the tribal areas of Assam, Meghalaya, Mizoram and Tripura, will not apply to those areas which come under inner line permit. For example, Mizoram, for example, Nagaland, for example, Arunachal Pradesh, for example, Manipur. So this law protects tribal interests, protects the interests of Northeast. That's the beauty about this law. But then there were others who said Parliament should not have passed such a law. Kapil Sibal, for example, the opposition leader, one of the brilliant constitutional experts as well, lawyers as well, he said Parliament should not have even discussed this law. This law is blatantly violative of the Constitution. But perhaps Mr. Kapil Sibal has not read the Constitution under Article 11 of the Constitution. What is Article 11? Article 11 gives power to the Parliament. That dear Parliament, you can regulate all matters related to citizenship. All matters related to citizenship. So Parliament, by enacting this law, is doing its duty, which is given to it by the Constitution under Article 11. Dr. B.R. Ambedkar, the architect of our Constitution, the drafter of the Constitution, he said it is not the intention behind Article 11 to lay down a permanent law of citizenship. If we wanted, we could have mentioned it in the Constitution itself. Who can become the citizen of India? Who cannot become the citizen of India? What are the qualifications required? What are the requirements required? What is the eligibility criteria? But it is not the job of the Constitution to lay down a permanent rule, a permanent law for citizenship, because citizenship law can change as well. And that's the job of the Parliament. So Article 11 has not been violated. In fact, Article 11 has been respected and upheld by passing this law, because it is the job of the Parliament to regulate all matters related to citizenship. And these are the arguments in favor of the Citizenship Amendment Act. And what will happen to those who are Sri Lankan Tamils? What will happen to those who are the Tibetan refugees? CAA right now focuses on persecuted religious minorities, focuses on religious minorities and persecution of them. Later on, we may take up the Sri Lankan Tamil case as well. We may take up Tibetan refugees as well. They may also be given citizenship, but right now the law is focusing on religious persecution. These are the arguments in favor of Citizenship Amendment Act. Any questions as of now? Any questions? Yes, no, maybe? Okay. Now let's look at the arguments against Citizenship Amendment Act 2019. The country was partitioned in 1947 into India and Pakistan. Pakistan became an Islamic state. India decides to remain secular. One feature of secularism is that citizenship will not be determined by religion. What is Indira Gandhi's citizenship status? Where does this question come from, my dear? Indira Gandhi is an Indian, was an Indian Prime Minister. What is her status of citizenship? Is there any dispute there? When the country was partitioned, does that mean that two states were created in the name of religion? Pakistan was created in the name of religion, not India. India decides to remain secular. And one feature of secular democracy is religion cannot be the basis of citizenship. And the first principal problem with this Citizenship Amendment Act is that this religion has now become qualification for citizenship. And when religion becomes qualification for citizenship, then you no longer remain secular. Secularism is one of the basic structure of the Constitution. And any law which violates basic structure of the Constitution is unconstitutional, will be struck down by the court. When citizenship can be given on the basis of religion, where religion becomes the qualification for citizenship, it clearly violates secularism, which is part of the basic structure of the Constitution. So CAA is unconstitutional. Blatantly unconstitutional. That's argument number one. Argument number two, Article 14 we discussed is dealing with equality before law and equal protection of the laws. And there we proved that Article 14 is not violated by Citizenship Amendment Act. But now we will prove that Article 14 is violated by Citizenship Amendment Act. Because it's a matter of interpretation. How you interpret it, how I interpret it. For you, for example, Mr. Rahul Gandhi may be a terrific, dynamic politician who showed his strength by walking thousands of kilometers from Kanyakumari to Kashmir. So he is not a useless politician. Others would say he is still a useless politician. So it is a matter of interpretation, how you interpret a particular event, a particular person, a particular thing, a particular law. Previously, we interpreted and said Article 14 is not violated by Citizenship Amendment Act. Now we will look at the arguments of those who say Article 14 is violated and blatantly violated by Citizenship Amendment Act. And for that, we need to go back to 1952, Anwar Ali Sarkar. Anwar Ali Sarkar judgment, court said, yes, there has to be intelligible differentia. That means you can segregate those groups, you can club some groups together, you can have another group, you can differentiate the two. But this classification should be reasonable. You should have the classification on a reasonable ground. And you should clearly tell us on what basis have you excluded some, on what basis have you excluded others. And for that, we need to understand Section 377 judgment. And what is Section 377 judgment? Listen to me carefully. Section 377 is part of Indian Penal Code. What is Indian Penal Code? All the crimes that can be committed, what should be the punishment for those crimes? That's mentioned in Indian Penal Code. What should be the punishment for murder under Section 302, mentioned in IPC? What should be the punishment for rape? Section 376, mentioned in the IPC. What should be the punishment for terrorism, waging war against the country? All these crimes and their punishment, they are mentioned in this law known as Indian Penal Code. Clear? And Indian Penal Code, Section 377 talks about carnal intercourse, that too against the order of nature. it is a crime for which you can be sentenced to life imprisonment as well. What is a carnal intercourse against the order of nature? Any sexual interaction which is not peno-vaginal in nature, which does not involve the two organs of male and female. Any such interaction which is not peno-vaginal in nature is a carnal intercourse. It's against the order of nature. It's a crime under section 377 of Indian Penal Code. And under section 377 of Indian Penal Code, homosexuality was a crime. Homosexuality was a crime under section 377. Because men having sex with men or women having sex with women, they do not involve the two organs of male and female. And as such, it's a carnal intercourse. It's against the order of nature. As such, it's a crime. 2001, NAS Foundation, a non-governmental organization, NAS Foundation, approached the Delhi High Court. NAS Foundation was working on men having sex with men. On this group of people, gays, men having sex with men, and they realized that there is an increased incidence of HIV/AIDS amongst this group, men having sex with men. And Delhi High Court was asked, please declare section 377 as unconstitutional. Please decriminalize homosexuality. Why? Because if a man is having sex with man and there are increased cases of HIV/AIDS amongst them, and we need to treat them, but they will not come up, they will not come out, they will not say that we are gays, because the moment they say we are gays, they will be arrested by the police because homosexuality is a crime. And this homosexuality, it's part of an individual's dignity. It's a sexual orientation. You can be straight, you can be gay, lesbian, bisexual, transgender, queer, intersex, whatever it is. So it violates the dignity of an individual under Article 21. That is why please declare section 377 as unconstitutional. Two-judge bench of the Delhi High Court, one judge was Justice A.P. Shah, ruled in the year 2009 that homosexuality is not a crime. Section 377 is unconstitutional because it violates fundamental rights. It violates right to life and personal liberty, dignity of an individual. But in 2012, in Kaushal judgment, the Supreme Court, because the matter now went to the Supreme Court from Delhi High Court, Supreme Court in 2012 said homosexuality is still a crime. Section 377 is constitutional. The court was asked why. The court gave multiple reasons. The court said, look, section 377, it is part of Indian Penal Code. Indian Penal Code since 1950 has been amended more than 33 times by the Parliament. But Parliament never thought it fit to decriminalize homosexuality, to amend section 377. So if Parliament does not do it, so how can we? It's ultimately a matter of Parliament. Parliament has to decide. Why are you coming to us? You go to the Parliament. I said, okay. Supreme Court was told, but there are individual citizens who are being violated, discriminated against. They are arrested, tortured because their sexual orientation is different. The Supreme Court said, how many lesbians, gays, bisexuals, transgenders are there in the country? Few lakhs, thousands. It's a minuscule minority. And for this minuscule minority, don't come to us. I said, what are you saying? For this minuscule minority, don't come to us. I said, but police is violating their rights. The court said, if the law is being misused, that's the problem of the police. That's not our problem. But be that as it may, 2012, Supreme Court said in Kaushal judgment that section 377 is constitutional. Homosexuality is still a crime. It was finally in 2018 in Nowtej Johar case. that Supreme Court said Section 377 is unconstitutional. Why? Look at me carefully. Supreme Court said, first, you are denying equality. You are violating equality before law, because you are discriminating against those whose sexual orientation is different. Second, you are violating Article 15. You are discriminating against your citizens on the grounds of sex. And sex includes sexual orientation. Sex does not only mean male or female, boy or girl, man or a woman. It includes those with sexual orientation as well. So if you are discriminating against somebody on the basis of sexual orientation, it is a crime. It's violation of fundamental rights. Section 377 is unconstitutional. But Section 377 was read down. This is where we will come to a little technicality, but I will make it very clear to you in simple words. Section 377 is not unconstitutional. It has been read down. Read down in the sense, Section 377, insofar as it criminalizes homosexuality, if it is used to criminalize consensual adult sexual relationship between same sex, it is unconstitutional. You can't arrest somebody who is a lesbian or a gay or a bisexual or a transgender. It's not a crime. But other forms of carnal intercourse are still crime. Which are these other forms of carnal intercourse? For example, bestiality. What is bestiality? Sex with animals. Sex with animal, it is a carnal intercourse against the order of nature. So if somebody is found committing sex with an animal, that is a crime under Section 377. If Section 377 was completely declared unconstitutional, then even bestiality would have been allowed. But bestiality is not allowed. The only thing which is not allowed is bestiality. The thing which is allowed is homosexuality. Homosexuality is not a crime. But other forms of carnal intercourse against the order of nature, for example, bestiality, it's still a crime. That means Section 377 completely has not been declared unconstitutional. It has been read down. Its implication has been removed. Implication in the sense, homosexuality is not a crime. One judge who was on this bench was Justice Indu Malhotra. She was part of the Section 377 judgment. And what she said? She infused Article 15 into Article 14. When we discussed arguments in favor of CAA, I told you there was an allegation that Article 15 is violated. Article 15 which says there can be no discrimination on the grounds of religion. And there I told you the justification is Article 15 is not applicable to foreigners. It's applicable only to the citizens. So CAA does not violate Article 15. But Justice Indu Malhotra in this Section 377 judgment, it infused Article 15 into Article 14. Is Article 14 applicable to foreigners? Yes. How Article 15 was infused into Article 14? Justice Indu Malhotra said, on the basis of the basic traits, core traits of an individual, you cannot discriminate. If you discriminate, that's violation of Article 14 because that is violation of equality. And what is this basic trait of an individual? Sexual orientation. What is basic trait of an individual? Religion. Religion is the core basic trait of an individual. So if religion is one of the grounds on the basis of which there can be no discrimination, this ground has been added to Article 14 as well. In a sense, when Article 14 talks about equality before law, law cannot discriminate against people on the grounds of religion because religion is the basic core trait of an individual. And since CAA violates citizens or foreigners on the basis of the core basic trait, which is religion, as such it is unconstitutional. So what are the arguments against CAA? Number one, when you make religion as a qualification to become citizen, you are converting a secular state into a theocratic state or a religious state which violates secularism, and secularism is part of the basic structure of the constitution, no law of the parliament can violate basic structure. Second argument, yes, Article 14 talks about intelligible differentia. Yes, Article 14 talks about you can have different groups and you can separate the two groups. But on what basis are you creating these groups in the first place? These groups cannot be created on the basis of the core basic trait of an individual. One such trait is religion. Religion cannot be the basis of discrimination. So having CAA, which classifies two groups purely on the basis of religion, it violates the Supreme Court's verdict in Section 377 judgment. That is why CAA is unconstitutional. What about other provisions, other arguments against CAA? We will discuss them tomorrow. So tomorrow we will talk about more arguments against CAA. Then we will link CAA with NRC and NPR. Then the citizenship chapter is complete. And tomorrow we will start a fascinating discussion on fundamental rights as well. If you have any question on CAA, park your thoughts, park your questions, shoot them tomorrow, because tomorrow we will discuss everything. I told you Hindu Rohingyas excluded from CAA. Why? We'll discuss that tomorrow. All this is not mentioned in Lakshmikant. That is why you join an institute where things which are not there in the books can be taught. Which chapter to read from? Citizenship chapter. CAA 120 days, less and more not getting. I never said anything in CAA which is 120 days. I may have said it with regards to non-resident status. If you are an Indian, you are residing in India for less than 120 days, but you are earning more than 15 lakhs in India, you are non-resident. But if you are residing in India for more than 120 days, but raising 15 lakh as income in India, you are a resident. You will have to pay tax in India. Okay, so let's meet tomorrow, 6 o'clock in the morning. We'll discuss the remaining provisions of citizenship, and then we'll start discussion on fundamental rights. See you tomorrow, 6 o'clock in the morning. Till then, have a great time, but you can always get in touch with subject matter experts. Get in touch with them for another 30 minutes till 10 o'clock, and they will respond to your queries. Done then. Bye-bye. See you.